you are speaking this evening, we ask that you please sign in. We also ask that you please direct all comments, questions, and concerns to this board. If you do need to discuss any matters with one another, please take it out in the hallway. It interferes with our opportunity to hear those that are speaking. And as always, we want to be courteous to each other as well as time for this evening. Before we begin, we'd like to have a motion to open.
I make a motion to open the Board of Architectural Review and Historic Preservation for October 14th, 2014.
Second.
All in favor?
Aye.
Welcome to the October 14th, 2014 meeting of the Architectural Board of Review and Historic Preservation. My name is Curtis Highsmith, and I am your chairman. We'll introduce our panel. Unfortunately, we do not have Christina Redding this evening. We would like to welcome Ham Hogue, who's not feeling well, so if he starts coughing, we will ask him to leave.
Absolutely.
Esther Pastor.
Start.
Brian Brady. Unfortunately, Zach Studenroth would not be here this evening as well, but we'd like to welcome our legal counsel, Bo Robinson, and Antoinette, as always, we welcome you. Our first application is sign permits. First application
Chairman,
is...
AC Lighting Electric for a storefront sign.
Antoinette, can I get that? Is the applicant present? The applicant?
Is that being represented by Hampton Signs, does it say? Anything on there?
Yes.
Okay, I'm present.
Is this a lit sign, backlit?
Backlit sign, yes.
Your name
Denise
for the-
Fenchel.
Okay. This is a backlit sign?
I think it's LEDs behind the letters.
Okay, so it's a backlit sign.
Yeah.
Yeah, this board usually does not allow for and does not favor backlit signs. If you look at throughout the entire village, you'll see most of the signs are either there's a projectory light, whether it be a goose down or goose up.
I think there's been a few approved lately. Home Nature comes to mind, maybe.
Home nature?
Home, right over here, Home, is it Home
An
Nature?
exception.
What?
It was an exception.
It was an exception?
Yeah, this is in Mariners Drive, correct? This application, your application?
Yeah, it's
Yeah,
Mariners.
I wouldn't vote for it. Surface light only.
Esther?
I'm not in favor of it.
I feel the same way.
Yeah, it's pretty.
So what does the board prefer, the goosenecks, or I just want to get a sense of where you're going with it?
Face light.
Anything with a
Gooseneck's
face light.
fine.
Anything with face light?
Nope, anything's fine.
Okay.
Anything further?
No?
Any public comment? You're asking the board to adjourn so that you can come back and present your
You
application.
want to delete the lighting, the backlit sign.
Right. But I want to
Motion?
represent it with different lighting options.
Correct.
Yep.
Motion to approve applicant's request to adjourn so that she can re-prepare her application.
I make a motion to approve applicant's request to adjourn AC Lighting and Electric.
Second.
All in favor?
Aye.
Next application, please.
Cavallo Building for contractor sign.
Is the applicant present? Hi.
I'm representing the building on this sign.
Okay.
I'm the
Contract
architect.
sign?
Huh?
Contractor sign?
Yes, right.
Your name, please, for the record?
My name is Joe Sosi. I'm also
Don't particularly.
Doesn't matter.
15 Pelham Street.
Font as well as color of your sign?
Well, that's his selection. I'm not involved in the design.
I'm sorry?
You don't like the color, you say?
I didn't say that. I just asked if this is the color.
Yes, a blue,
As well as design
blue
that you-
background, yes.
Okay. Esther, do you have any comments?
It's a little busy, but I'm okay with it.
Ryan?
I'm fine.
Ham?
A little busy. It's better if it just says the name and the number or website, logo.
Do you have to have fine custom builders?
Yes.
Okay, why? Is it an advertisement? Is it something?
No, it's just
is it part
the
of
sign
your-
that will go on the property, yes, it is being
No,
built.
you don't, okay. What I'm saying is, would you be opposed to us removing the advertisement?
You mean the background, just the name of the builder and the phone number? is that what-
Fine custom home builders, that's removed from the sign.
Okay, I will tell him to remove it, yes.
You'll tell them to remove it?
Oh,
Are you
yeah, he
sure?
will. Yeah, sure, I'm sure, I'm the architect, I'm his architect,
You're his architect.
so I will actually tell him to remove it.
So you're going to...
What
if-
about the logo that is next to
They
it?
have no issue with the logo, it's just the advertisement.
Yes, all right.
So you're going to go back to your applicant, I'm
I
sorry,
will
to your...
definitely will, yes.
Okay, and you're gonna let
He
them
gave me
know
the
that the
free-
sign will be approved, but it will have to remove the
Yes, right.
advertisement.
Yes.
You understand that?
Can I keep the phone number with the background of?
Yes.
The only thing you're removing is the advertisement.
Okay, I will tell him that.
Is there any public comment on the application? Okay, motion to approve with the condition of removing Fine Custom Home Builders.
I make a motion to approve the sign for Cavallo Building with the removal of the wording Fine Custom Home Builders.
Second.
All in favor?
Aye.
Next application is, for Chris Gaynor Construction Services.
Christopher Gaynor for C. Gaynor Construction Services.
Contractor sign?
Yes.
Name, construction services, builder of fine homes. It's a lot of advertising going on this evening. Is that the background?
Yes, sir.
I'm sure that it's going to be a replication of what the last application is. We'll ask some questions. You have,
If the chairman would
You have
permit,
something part
I've already figured that was going to happen. So I'd like to resubmit that for approval.
Looks good.
like preparation.
You have two
Any
copies
public
of that?
comment on the application? Board members, any issues? Nope.
Nope, looks great.
Motion to approve.
I make a motion to approve C. Gaynor Construction Services.
I'll second that.
Thank you.
All in favor?
Aye.
Concludes the sign permits for this evening.
Mr. Chair, next application on the agenda is
Before we
4:15,
begin,
but
just
we're
one-
pushing that back.
Well, before we begin, that's the reason why we just want to address the public with regards to, I'm sure, the pending potential change in legislation within the Village of Southampton as it pertains to properties that are influenced by height due to FEMA. There was a moratorium, and there's information that will be going, that has been sent for potential change in legislation. While that's been said, it's a recommendation that this board hear applications, but there will be no decisions this evening for any of those applications that are heard. So, with that said, it's your discretion to give commentary, your discretion to give your presentation. However, this board, with the pending legislation, would not take in consideration making any motions to approve or close the application until such time as we figure we are informed with the change in status of the information that's going out. Counsel, do you have anything to add to that?
No, well said.
Okay,
I'd like to be heard on that.
I'm sure you would. Okay, when your application comes forward, you can,
Okay, but it's important because I don't want anyone to leave under the impression that I will not try to convince you on 320 Murray Place, which is not in the historic district, to make a decision.
understood.
Thank you. But I didn't want anyone to leave
Okay,
under that impression. And I
Un-
certainly would like the opportunity to be heard on it,
yes,
on that procedural point.
understood.
Thank you.
On the 450 Gin Lane, there was some commentary about a special discussion from the opponents of the application with this now change in possible legislation and this board's the direction to not vote on any given application but remaining open, as that's still something that the opponents wish to do in light of the new changes.
Good evening, Mr. Chairman and board members. My name is Jeff Bragman. I represent Neil Smith and some of the other neighbors who are in opposition. I understand from John Bennett today at 4:30 that the plan is changing and that he's submitting a new plan this evening. And so I'm not prepared to present the same case that I was prepared to make the last time I was in front of you. I'm going to withhold and see what Mr. Bennett has to say. I wanted to say for the record that I got those new plans at 4:30 this afternoon, so it didn't really give us a heck of a lot of time to look them over. I would ask the board not to comment on the new plans. I think it's important. It's important that we have an opportunity to give you opposition on it, but given the timing of it, it's unlikely that that is going to happen before the moratorium kicks in tomorrow when it's filed with the Secretary of State. Maybe I should. I'm sort of hesitating because I want to talk to you about another issue, which I think is probably the more important and direct way to address this. So I want to talk to you about the law a little bit. Tonight I've served the chairman of the ARB with a certified copy of the moratorium law. I did that because Article New York State Village Law, Section 7706, permits us to serve a certified copy of the mailing of the enactment. And the service of that certification about the local enactment triggers its effectiveness, notwithstanding the fact that the Secretary of State has not yet filed it. This local law was mailed out on Friday morning. It arrived in the Secretary of State's office Tuesday this morning, and our understanding is that it will be filed tomorrow. But New York State Village Law 7706 permits us to file with the chairman of the board a certified copy of the law indicating its adoption and that it's reflected in the minutes of the village board, and that acts to effectuate the moratorium, and it stops your ability to hold a hearing on 450 Gin Lane.
Once it becomes adopted.
No. Now, as of
Certified local government?
as of the time of the service of the certification, it stops your ability to hear the case. And so I'm saying for the record that the board does not have the legal authority to hear Mr. Bennett's new presentation. It is clear, the law is quite clear about the method of procedure. I can read it to you. I have it with me today. And I think I will read it just so it's in the record. It says, effective date, such local law shall take effect upon the filing in the office of the Secretary of State, but such local law or amendment shall take effect from the date of its service as against a person served personally with a copy thereof certified by the village clerk and showing the date of its passage and its entry in the minutes. That's what we have given you tonight before the meeting. And
Jeff,
that makes...
Excuse me, can I interrupt you just for a second? John, do you intend to make a presentation tonight on this?
Absolutely, his recitation of the law couldn't be more incorrect, and I'd like to speak to it.
Okay, but that aside, do you intend to address...
Absolutely. There's nothing, you cannot, I litigated this case when the
No,
village...
not the law.
please.
Sorry, I don't want to distract you. Do you intend to make a substantive proposal addressing the architecture on this tonight?
Yes,
Okay.
absolutely,
Right,
as
then-
is my right under the law. And I'd like to be heard on the law which has been mischaracterized at a minimum.
You know, John is going to have an opportunity to address the board. I'll address the board. I'm not going to engage in a lengthy debate with John Bennett. I'm going to tell you what my understanding of the law is. I believe the board has stayed. It's very likely that you're going to hear, and I don't like to do this, but with John, in order to fend off interruptions, I'm going to make some assumptions that he's probably going to say to you that that there's something different about a moratorium, and we shouldn't have the power to do this. The fact of the matter is that New York State has a long-established body of case law that definitively define zoning moratoriums as zoning enactments. What they are is they are interim zoning enactments or they are stopgap zoning enactments. But there is nothing separate and apart about a moratorium that makes it a non-zoning statute. A local law that freezes your height rule and prohibits your board from conducting any hearings in cases in which the height rule is relevant is a zoning enactment. It is enacted under the zoning powers that are granted to the village under New York State Village Law, Section 7-700. It's a long line of cases in the state of New York. It can't really realistically be argued that it is something other than a zoning enactment. In addition, you may hear, I don't know what Mr. Bennett plans to say, but you may hear that there's something different because in the 450 Gin Lane case, we're hearing the case under Chapter 65 of your local village code. Chapter 65 is the historic preservation section. That argument is also incorrect because under the general grant of zoning powers in 7700, that's the source of the village's power to enact Chapter 65. So what I'm saying is, I know I'm saying this a little quickly, but I want to make sure that the record is clear on it, that when a village board enacts a zoning moratorium, it is by definition a zoning enactment. And because it is a zoning enactment, it falls under the rules in Article 7 of the New York State Village Law. And under Article 7 of the laws of New York State Village Law, we can make the law effective by serving you a certified copy, which we have done. And in addition, the fact that the 450 Gin Lane case deals with the requirements that are in Chapter 65 doesn't take it out of this section of the New York State law because that's the source of the village's power to create the ARB and to enact historic districts. And in fact, Section 7-700, which is the grant of zoning power, explicitly includes protection of historic and aesthetic resources. So in our opinion, you are stayed from hearing this case, but on a practical level, I wanted to say that it's, last week when I asked for some time so I could have an hour to present our case, Mr. Bennett stood up and accused us of trying to ambush him. He said this is a hearing by ambush. I got a new...
We have it on the agenda for today.
I know, I understand that. I have a new set of plans that was delivered to my office that was sent to me at 4:30 this afternoon. I want to hear what he has to say if you decide to let him make a presentation, and then we'll see whether we have time for opposition. But I would ask you, of course, not to close the hearing. And my preference would be, or my suggestion would be, I think, that the board would agree that the opposition or that a critique of what Mr. Bennett is going to give you today is certainly reasonably necessary information for you to hear, and I'd ask you to kind of withhold making a judgment or a decision about the plan until we get a chance to address you.
Which, in my opening statement,
which may or may not. I mean, we don't know how long the village will take. It could take quite a while.
Seeing that I've just received your notice today.
Thank you.
And the information that you received, I think myself, the board, and our council need to discuss in detail what the proper protocol is going forward, especially during this very unique moratorium where I think it's unique to both not only germane to this board, but just in the village as a whole, where what our jurisdiction would be going forward. So I think I would lean towards my council's advice. I will have to lean towards my council's advice more so on the direction on how we handle this, especially in your
It's interesting to me that Mr. Bennett asked the village board specifically in front of them when they were, on the night they enacted the moratorium, if they would delay sending it out to be filed so that he could make a presentation tonight. And they did not honor that request. And it's our position that this section of the law precludes you from hearing the case, but I leave it to you and your counsel.
Thank you.
Thank you.
Thank you. Heard on that.
Beforehand, Zach, Bo, is there anything that you wish to add to that?
Well, I'd like to, before you...
Mr. Bennett should be heard, and then we'll...
Okay.
First of all, let's talk about this. It's Section 7-706.
Can you clarify for the record which application you're speaking of?
I'm speaking on 450 Meadow Lane,
450 Meadow and 450
but I'm also
Meadow.
speaking on 320 Murray.
Mr. Chairman,
Okay, we're getting out of order now. The application is being heard today. Right now, at this moment, is 450 Gin Lane. Thank you.
All right. So you look at 7-706 and subsection 7. And by the way, what I'm about to tell you today this evening is not just the way I read this law, but it's the way I read this law. And I called the village attorney today, who, as you know, is the trustee, counsel for the trustees, and he agrees with my reading of the law. So I want you to take that into consideration. The law doesn't say what Mr. Bragman says. It says he wants it to say what he thinks it says, but it doesn't. First of all, Section 7 talks about service as against a person shall take effect from the date of service as against a person served personally with a copy thereof. Is it a certified copy, certified by the clerk?
No.
Excuse me?
Yes, it is.
Okay. Take effect. The purpose of this section, if you look at the what we call the session laws, is so that a municipality, if it wants to serve a person with a zone change or a change in dimensional regulations or something of that nature, doesn't have to wait to the filing with the Secretary of State. Rather, they can serve the property owner with the law. That's the purpose for this law. So it doesn't work as against a board or as against a village. It works as against someone who is trying to take an action while a law has been yet to be filed, and the filing of that law, the acknowledgement of that receipt of that law has yet to come back from the Secretary of State. But it's a person who's it's filed against it can be served against a property owner, number one. Number two, while there are some procedural regulations regarding referrals that moratorium have to abide by, such as a referral to the Suffolk County Planning Commission, this Section 7-706 does not apply to moratoria. There's nothing in the law that says it applies to moratoria, number one. Number two, and as Mr. Bragman correctly anticipated, probably because he knows that's a problem with his argument, it doesn't apply whatsoever to Chapter 65. You don't have to trust me. These are, and as an officer of the court, I will affirm to you that these are the conclusions both that I reached upon my reading of this law and Mr. DePetris, the village attorney, reached with the reading of this law. So there is nothing in here that stays your ability to hear this until the actual effective date. If Mr. Bragman were to, even if my position is even Mr. Bragman were to serve the property owner, it wouldn't be effective because it's not effective as to these types of laws. But even so, it isn't effective as to Chapter 65 changes, nor is it effective as to moratorium. So you do have the ability to go for it. The law is not effective until it's been filed with the Secretary of State and receipt of it has been acknowledged. I met with Mr. Funch today, the village administrator, at approximately 1:30, and he informed me that he in turn had been informed by the Secretary of State's office that the law will be deemed filed tomorrow. So, and then finally, and because I did have the occasion to litigate this matter against the village of West Hampton Beach, in a matter called Five Corners School versus Village of West Hampton Beach. It's an unreported decision, but again, I was counsel for the applicant, and the court was very critical of a board that took an action in anticipated effectiveness of a moratorium. So, and then finally, from a purely practical point of view,
What do you mean by anticipated?
it hadn't been effective yet, and the board took an action as if it had been effective.
Had been, thank you.
I apologize for
So in
not
other words,
being-
holding decision, waiting for the anticipation of a decision in moratorium is not the same as acting on behalf of an effective or a favorable decision on a moratorium.
No, you can't. You have to, until the moratorium is effective as against you, for legal purposes, you have to assume that it doesn't even exist. Because if it hasn't been filed and the receipt of it acknowledged by the Secretary of State, that is not the law of the village. And finally, I don't think anyone's kidding anybody. You're certainly, as it relates to 450, it's in the historic district. You've never, nor can you, render a decision on the evening of the hearing. Certainly, at a maximum, you would close it and give some direction to Mr. Robinson, but it's probably unlikely that you're going to do that. So I think this applicant has been through a long process here. We're trying to get some feedback from this board. There is a change. I gave it to Mr. Bragman, but it's been filed for about a week now. So as a courtesy, I sent him an electronic copy today, but it has been filed since last week.
For the record, what was the date it was filed at the building department? October 9th.
Last Thursday. So, it's sort of
it was
good.
ready for public review on October 9th.
On October 9th. So again, I don't want to be criticized for courteously sending him a copy electronically today, so we would have it to review before this evening, but it was in the office on October 9th. So I'd ask you to let the hearing proceed.
Thank you. Counsel?
The trustees have displayed their intent to impose a moratorium on the conduct of this board of the building inspector, which involves the subject property. That's been going on for many weeks. That process was actually delayed because the trustees had to await the opinion of the Suffolk County Planning Commission, which rendered a decision approving the moratorium. The trustees met, approved the moratorium, acted with remarkable dispatch in sending the document to Albany Friday for filing with the Secretary of State. That document, I'm told by Steve Funch, was delivered to the Secretary of State the first business day after Friday, which was 7:30 this morning. Due to whatever procedures go on in Albany, he was later told in the day that the document would not be filed until tomorrow. So we're hours away from having this moratorium officially imposed with all the I's dotted and T's crossed. You are an administrative board. You're not a judicial tribunal. We have heard the opinions of attorneys tonight on the interpretations of village law, which itself could be the subject of court litigation. I don't think that this board is wanting to get involved in that, nor should it be, nor should these kind of decisions be visited upon an administrative board dealing with the architecture of a municipality. I don't see what is to be gained by further presentation of anything this evening, since your board will not be rendering a decision. And I think your board would be well advised to, as a function of the village government, to understand the direction the trustees are going and act accordingly to support, their decision. For whatever reasons they feel they want to go forward with the moratorium and change the law, and to make a presentation further this evening based upon the fact that as we understand it, is going to involve an amended plan. And once the moratorium is over, if there is a height change, then it may well affect the architecture of this building. And certainly in 6 or 8 or 9 months, nobody's going to remember what was said here tonight anyway. So I would have to, at least I won't. So I think that the chairman's opening statement was well taken. I don't think there should be any further presentation on this, and the matter should be really adjourned for all purposes as of now.
On 450.
On 450 alone.
I have the greatest respect for you, but I don't know how to say it other than you're dead wrong. It's unfair.
I hope the board will note your objections.
Yeah, no, but it's unfair. This applicant has been before you for a long time. We've moved the application to the point where I think there's a substantial change in the application, and it's been on file, and I think there's no reason why we can't hear your opinion on that There's no legal impediment whatsoever. The fact that the trustees had an intention, that's all well and good, that's fine. The fact that the moratorium will be effective tomorrow, I understand, I accept that, but it does not change the fact that you have an obligation to go forward and hear this decision, hear this matter. It's been filed before you. There are 4 of you here. I have the right to present this case and to hear what your input is. It may be very, very, very helpful to the applicant in terms of where your heads are at on this application, and it may be changes that you find he's got the message, and you maybe want additional changes. But to put this applicant, who has been in a 6-month process, into a situation where they can't present something to you because of a law that is not in effect is inequitable, contrary to the law, unfair, and particularly unfair to the applicant.
The changes that were done, were they impact to height, or is it just aesthetics?
It's aesthetics solely.
Solely aesthetics.
Solely aesthetics, which is why. Well, no, it changes the height. It does change the height, but again, the height change comes as a result of trying to respond to what at least I heard very clearly was this board's direction aesthetically they wanted us to go. So I think in all fairness, you had this set up for a hearing.
Well,
you put it at the end.
Question: if this board hears this application this evening,
yes,
and understanding and with the commentary previously had by myself, that this board would not make any recommendations or motions to close the meeting and would remain open.
Well,
it
will remain open. I understand that. Yeah, that's fine.
So,
I wouldn't have expected anything. I wouldn't have expected you after a new set of new elevations and opposition here that it said is going to take some time. I wouldn't
moratorium
expect
goes
you
into
to
effect, and then there's a change in legislation based on height, and then we would have to go and review another application by you because
you may or may not, based upon how the trustees respond to my request for an exemption, which will be filed within a couple of days. But as I said to the trustees, and there was nodding of heads, it may be very helpful for them in the course of that exemption application to see how you feel. This applicant's been before you for some time. We've made a substantial change. I have the right to go forward, and I think I have the right to see what your input is. And I would respectfully request that you do that. I understand what Bo's talking about, and it's very difficult to have such a stark disagreement with someone that I have that much respect for. But I do think that's the wrong way and an unfair and an unequitable way to go about it.
As a member of this board, I would feel really uncomfortable making any recommendations, suggestions, or any comments on an application when there's so much pending in terms of both legislation, as well as your intent to file I guess with some
it's called an exemption.
The exemption to. So not knowing going forward, I wouldn't feel comfortable making any recommendations. If
All
you
right, well,
do
I'll go forward anyway.
If you do present, that presentation would go, I won't say in deaf ears, but it would go as just a presentation, and then
all right, that's fine.
A wait to see what would happen.
That's fine.
Council, do you have any objections to that? Because from practical standpoint,
I have no objection, but just 2 comments. One is that there's no right of the applicant to go forward. The law may not be in effect, but you certainly have the discretion
At this time.
to go or not go.
How?
And secondly, because they do.
How?
Because they do have the discretion.
Yeah.
I don't think you do.
This is the eve of hours away from the imposition of a moratorium.
But it's
John,
not
let me
effective.
finish.
I'm sorry.
And the second part of that is that, all these public hearings are discretionary to begin with. The law, our code says you have the discretion to have a public hearing. You don't have to have it. So if you don't have to have it, where is the right to have it?
No, but
You have begun this process and you're in the middle of it. But clearly the trustees have spoken and indicated where they want to go with this.
But once you open up once you decide that you want a public hearing, which you almost always do in historic cases, once you decide, I have the right to proceed.
Understood. The application really has not been called as of yet. We've been hearing dialogue. And
Right.
as it stands right now,
Right.
this application is still, we haven't even called a historic application thus
Correct.
far. It's just been dialogue over the presentation, with the understanding that there's a moratorium, there's a possible change in legislation. So as of right now, the application has not been called. So is there a call for the application to open this evening?
We
Not
have
by
it
me.
scheduled towards the end of the evening. Look at your calendar.
You have the right to revise the calendar.
You can revise.
Yeah, my copy, they didn't do that.
Well, let me read it for you.
I think
No,
that was for
I-
my benefit. That was,
Oh.
Yeah, okay, I see
you're
you, the
controlling the agenda.
conclusion of the meeting, I understand. All right, so the application has been called. It is in the agenda to be called at in the close of this meeting. We're going to go further with our agenda for this evening, and if there is a motion of this board to open the application, we'll do so.
Okay, thank you.
Next application, please. Pending written decision.
Application pending written decision is David and Sylvia Hermer.
Yeah, the application.
Written decision is not.
The decision will be available at the next meeting, and I have so informed the representative of the applicant.
Okay. It's already closed, doesn't need to be
You don't have to do a
motioned.
thing.
Closed for written.
Next application,
Next
please.
application, Mr. Chair, is 436 Gin Lane.
In the file is a decision conditionally approving the hardship application pursuant to the consensus of the board. The decision is conditioned upon the applicant having authority to remove the easterly addition to the property and some additions to the west under the supervision of the historic consultant to the board, with the board retaining jurisdiction of the application, so that during the construction or deconstruction process, there is a dispute or questions regarding what should remain and what should not, or how it should proceed, that the historic consultant has authority to render consultation on that, and should there be an impasse, then the matter will come back to the board for its determination. So an affirmative vote on the motion would be to approve the conditional decision.
Motion to approve a written decision by council with all of the amendments that are a part, as well as agreements by the applicant on the project as a
For
whole.
limited deconstruction.
Yes.
Correct.
I make a motion to approve the application 436 Gin Lane for limited demolition of the east and west wings, and to deconstruct in a careful manner under the guidance of our, or under the oversight of our historic consultant.
Second.
All in favor?
Aye.
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 Next application is Thea Lorber, 47 South Hill, for 2 sets of driveway gates.
The applicant present, please.
Good evening, my name is Terrence McKean. I'm representing Will Manier Architect. A little handout for you.
Is this representing what's in the file, or is this any?
Yes.
For the record, posting and mailing are in file. It's original, you guys.
I'll start with the pool house first. The pool house is 170 square feet. It's basically 2 pods. One's a kitchenette, one's a bathroom with a shower. There's a connecting trellis that goes between the two, which is basically a sitting area. That area is roughly underneath there, about 262 square feet. The detailing matches the existing home. The trim is all white, as well as the trellis.
Does this mini set match the filed set?
Yes, sir.
That question was asked. And
Sorry. I don't have any issues with this.
I have no problem with this.
the driveway gates?
Yes, and the driveway gates, I believe there's a picture in the file there. Like, do you need this, or?
No.
It's basically a white slatted gate with 2 trimmed pillars. It's pretty simple. They are actually not doing the circular driveway. They're actually just doing one direct way to the actual garage itself, so there will only be one gate.
You don't have an amended site plan?
Correct. It was just brought to our knowledge, actually, as per the,
Just to let you know, the application is incomplete until that's part of the file.
Yeah.
okay, so can I get approval on just the,
Application is incomplete until that's part of the file.
You're indicating both gates on the survey. You have to clean up the survey.
I was wondering if I could get approval on the actual pool house itself, no?
The application needs to be whole.
Okay.
Also, on your driveway gates, if you could dimension the spacing between your spindles, it wasn't on there.
Okay.
What is the spacing for the record?
It looks to be about 2 inches.
Can you indicate on plans, detail please?
Would you like a detailed plan indicating?
Yep, on every one of our applications.
I had a feeling you were going to ask for that.
So you're requesting an adjournment to...
Hold on, hold on. Take it easy. Is there any public comment on the application? Anything further from the board? You have homework to do, so.
Okay,
you're
thank you.
You're requesting this board to adjourn so you can finalize your application, correct?
Correct.
Motion to approve applicant's request to
I
adjourn.
make a motion to approve the applicant's request for adjournment, 47 Hill Street.
Second.
Construction driveway gates and accessory pool house as well, or are we voting on the pool house this evening?
Oh, there's no vote. This is adjournment.
Okay, thank you.
Been motion is second. All in favor?
Aye.
Aye. Next application, please.
Rothfeld, rather, sorry.
Three 19?
Yeah, Rothfield?
That's
Yes.
Good evening. Mike Sauter, representing Mr. Rothfield on driveway installation, driveway gates.
Spacing between the spindles.
3 inches.
Sorry?
It's 3 inches.
3 inches. Wood? White
Yes.
trim?
Yep.
Any lantern being proposed?
No. Just as it is.
Brian, comments?
No, I think it's appropriate.
Esther?
I agree.
Pam?
Fine.
Any public comment on the application? The property is located in the historic district and therefore requires written decision for approval. This board is approving of the application, so at our next meeting, we will prepare the written decision. As of right now, the application will be adjourned and closed for written decision.
Okay, is there a date on the next
The next
architecture?
meeting is 28th.
20. Okay.
Okay, any questions?
Thank you very much. No, that's it.
All right, motion to close the application for written decision.
I make a motion to close the application for Eric Rothfeld, 319 Halsey Neck Lane, for written decision by council.
Second.
All in favor?
Aye.
Aye.
Thank you.
Next application, please.
Gugliotta, 44 Lewis Street.
For the applicant, John Bennett, Mr. Gugliotta is here with us this evening, as well as David Duncan, the project architect. I want to hand out a couple of things for you. First of all, what we have on the board, we've tried to show you the different sides of Lewis Street to give you an idea of the area in which this proposed demolition and rebuild is taking place. Although there are a couple of different schools of thought on this, sometimes when you're trying to remove a house, it's sometimes thought to be good, even though there's nothing in the code that requires it, to show the board what the proposed replacement is. So what I'd like to do, and also we have, although this is not a hardship hearing, I thought it might be helpful for the board to see an engineer's report on the matter. So we have plans for the proposed new house, an engineer's plan, a report on the house.
And just to reiterate, just to upgrade to your comment, even though it's not a requirement that we ask to see what the structure will look like after demo, it does also state in our code that it would be helpful and should take in a recommendation to do so going forward. So.
Okay, good. Yeah, again, there have been times when there was, at one time, I think the board was hesitant to look at that stuff, but I think it probably is.
How many copies did you give us?
Helpful.
Lot.
There's a lot of them.
Yeah,
Yeah.
like 12. no,
Oh, okay.
15.
You can hand me back the ones.
Volume 1?
And
You want to hand
few
it down?
handouts of the large board, so you might be helpful. That might be helpful. Now, the existing house it's in the historic district. However, there's no what I call blue sheet on the house, which means that it's not in that. If you go into the building department, there are many homes in the historic district that have a write-up from the state historic representative that came out in around 1979, and if he or she thought that houses were of particular significance, there was a separate write-up on it. There's no, and they're originally blue in color, so that's why I call them blue sheets. There's no blue sheet on the house. It's not on the state list. Is with the other thing that you go through, and you'll see that there are houses on the state list. There's a letter from the neighbor to the south that talks about the house as being part of the Lewis Street Historic District. However, as the board is aware, that was a proposed historic district that never came to fruition. And while clearly the existing house there is a pleasant home, it doesn't, we submit, rise
Historic
to...
gateway in the village.
Excuse me?
This is a historic gateway into the village.
Lewis Street.
Yeah, so the engineering report is for what reason?
It's I'll make my presentation if that's okay. I find it easier and probably more succinct just to be able to make the presentation, and obviously I'm here to answer whatever questions you have. Thank you. So while it's a pleasant home, it doesn't rise to the level of preservation. We submit. The architect is unknown. The house itself has no significant provenance. There are no historic persons attached to it. And I think it might be helpful because sometimes probably the best person to have an idea of, any historic benefit of the house is the people that owned it for many years. I do have a letter from Veronica Storm Brown. It's very short. I'd like to read it into the record. She was the owner of the house before it was sold to my client. Dear board members, our family, Schwenk and Storm, have owned the property and home at 44 Lewis since 1914 and have recently sold it. My 95-year-old father, Henry Storm, had been its last occupant until his passing in June 2013. While we have the fondest memories, the functional and useful life of this house is past. The house has fallen into disrepair and has not been updated in many years. The house is a Dutch colonial design that is simple, lacks any remarkable architectural elements. I'm in complete agreement with the demolition and the subsequent replacement of the home. I've reviewed the plans, the replacement plans, and believe this is a positive step that will also increase the property values of the surrounding homes. I look forward to the board members' favorable opinion for demolition and consent to build a new home on Lewis Street. I regret that I'm unable to attend the meeting and have requested this letter be distributed to the board and read out loud. So that's the homeowner of the property until recently. Again, it's a gambrel shingle-style cottage, nothing out of the ordinary, simple in design, lacks any remarkable architectural elements, and I'd like to ask Mr. Duncan, who's the project architect, to come up and explain two things. One, what would be replaced if one were to attempt to rework this house, and then also to talk to you a bit about the what the proposed replacement would be.
Are you presenting a replacement cost? So you're leaning towards the hardship? We're going down that?
No, I can't do that.
Okay.
No, I can't, that's
why we're not, I'm going to make that comment now. So we're going to start going down that road.
Not cost, just what he would have to replace.
Very good.
So, and Mr. Duncan also has a model of the proposed replacement home. Oops. If you'd like to say a few words, David, about the about the existing house and then talk about the proposed replacement house.
Sure. Get my hedges back here. Can you see this very well from here? Sometimes it's better to look from down the street, but street level, but that's a good start. Let me just quickly orient you. This is Lewis Street, this is north, and that's south. The existing house is generally in this area. You have a site plan in your package, and what I've done is I've outlined the existing house in red just to show it. So the existing house comes to about right about there. Just for some comparison to the sizes, and sort of the general approach. I mean, it is what we tried to do with the house is recognize it's actually a very sort of understated neighborhood. It seems to be very quiet, and what we were trying to do is kind of keep with the same rhythms and the same general look of the house that's there. So we've kept the gambrel facing the street. We actually narrowed it up some, and I can go into that in a minute. And we tried to maintain as much of the open space as we can on the south side of the street, south side of the property, which is what the current house does as well.
Can you just turn it so I can see the Lewis Street impact?
Sure. Let me, you know what? I'm going to try to prop it up there.
I don't want responsibility.
So as it happens, we've actually done some things that are slightly different. We've actually, on the very front piece of the house, we've actually narrowed it up from existing 26 feet to about 24 and a half. And then the next piece over, we have actually narrowed it up from 36 feet to 29 feet, which is right in through here. And the existing house actually is about 36 feet, and this is 36 feet in width. So we basically maintain the same width of the house that's there now. The way it starts is there's an entrance porch right here. It moves around to the side. There's a dining room. This is a screen porch, which is actually sort of reminiscent of the existing porch, sort of inspired by there's an existing sunroom there right now, which is right here, and then we have a screen porch back here. The current garage is here, although we've made it smaller. The new garage, proposed garage, is back here. That's an existing tree. It's a pretty big tree. It's a Norway spruce, about 30 inches in caliper. And then the pool is located here. And these hedges pretty well represent what's on the property right now, just to kind of give you a feel for what it looks like. We've tried.
You lost your backyard.
Oh.
And your side yard.
And so these hedges, you know? So I'll leave these off. They're meant to come off.
They were that easy to cut.
I'll pull these off. How's that? So in mass, and we've also tried, I've spent quite a bit of time with your architectural manuals, and you can see very clearly that we've taken the original gambrel form, and then we've done sort of an additive approach to a classic American shingle-style house. I do have some photographs here, if they would help. This is the tree. I can hand all this in. I can hand it around. There's the tree.
Just 2 copies,
Yep.
please.
Okay. The tree. This is the existing garage from the side and from the long side. And I do have some just general photographs of the hedges that are really quite tall around the property right now. So I'll put those in. Thanks. I mean, really that is the layout of the property. I'd be happy to answer any questions that I
You spoke a lot of the trees that exist. Do you have a current landscape plan in mind?
We do not have the landscape plan in mind yet.
Will you be adding any, at this point, you don't know if you'll be adding any trees, any more bushing, any more covering, or
The first thing
screening?
we're going to do is try and take as many of the existing plants that are there now and burlap them up, because there are some pretty nice, some nice specimen hollies and a few other things. So we're going to try to protect those and keep them on the site. The landscape plan gets to be pretty individual, and people have different ways they like to see the landscape. So, but I think what we're going to be doing is, that there actually right now, I didn't show it here, but there's a garden started over here from the front. I didn't put it there because it didn't really show on my surveys, and this is really sort of where the hedges stop. So we're going to continue this through. This is the driveway coming in from here. It's currently the driveway. We're just going to keep it in the same place. So for now, that is the landscape plan.
So the driveway, and that's the north or south?
This is on the north side,
North side.
and it comes in right now. It actually comes in right
And
now.
then what is the
kinda-
height of the hedge that's running that parallel to the driveway?
This one's about 9 feet right now. Just measured it. This one over here, it gets pretty bushy and tall, which you can see from those photographs. But that looks like the best I could measure, about 18, 20 feet, something like that along here. We're going to be continuing that along. That's already here. We're going to continue that across the back. And then the hedges here, they're actually kind of a mix of different kinds of plants. It looks like some big privet hedges and some arborvitae. But I just try to represent that with this. And they're about 10 feet high.
Okay.
Thank you. Anything further?
I was wondering whether or not Mr. Studenroth had been able to look at this.
Mr. Studenroth's not here.
No, I know
I was
that.
actually looking in the file to see if there was a workup or markup. I know there was some verbal discussion on the application, but nothing that
Okay.
has been part of the file.
You'd have to refer it to him, I assume.
I will most certainly, it would be as the chair of this board, the recommendation that we refer to Mr. Studenroth, mostly because you made a comment about it not being on the blue sheet. Does not mean that every property that does not exist on the blue sheet is not significant.
It's also discretion.
It's the discretion.
No,
of the
no,
board.
no, I understand
We've
that.
seen many, the blue sheet are interns years ago that were walking around the community writing up work. It doesn't necessarily mean they got every property of interest. So we would need more data and information from our historic consultant before we would even consider the certificate of appropriateness on this one.
I understand that. I do want to let you know that I did, again, speak with Diane in the building department today to double check the fact that there is no blue sheet on the matter, and
Yeah, I
her
understand.
review of the state list said it wasn't on there. But it's a factor, but I understand it's not conclusive. I understand.
Thanks, John.
Any public comment? Please step forward.
In 2000,
Name for the record.
Kathy Bellows, 52 Lewis Street. In 2000, this board received a CLG grant, and all of the contributing properties in the historic district should have a blue sheet or an inventory form. If there is not one there, I would like to know why, because there should be one there. This house is on the National Register of Historic Places. This is a contributing property. I believe I handed in part of the National Register of Historic Forms inventory, the nomination forms. This is on the State Register of Historic Places. This is on the National Register of Historic Places, and it is a contributing building. In 1987, it was put into the local district, along with the rest of the national, the rest of the 79 survey. So it is in our historic district.
You have documentation to support that?
I surely do.
Because I don't have it. We hand that so she can
Could you
stamp
put it
it.
there so it can be stamped and entered?
Got a lot. What you have here, if you read the list that Mr. Bennett gave you, all of the houses on Lewis Street that are on that list are not in our locally designated lands district, okay? All of there are 8 houses that are contributing, and they're not on this list. I also have, this is the National Register of Historic Places inventory form, and that's the copy that I gave you regarding this property on 44 Lewis Street. There is a copy of this in Washington, D.C. There's a copy of this in Albany, and there's a copy of this in Riverhead. and there should be a copy in the village. So there should be no question that this is a historic property. I think the confusion is that in '93, the National Register District was expanded, and that's the list that you have, but you don't have the local. Okay?
Yes, ma'am.
Do you understand?
I understood. I don't know if you heard, but that's why I made the statement that I made with regards to just being identified on our blue sheet as it was labeled.
There should be a blue sheet for all of the contributing properties. No, there should be one in the building department because this board did get a CLG grant to complete all of those blue sheets in 2000. So I don't know why it's not there.
I don't have that answer, so.
I don't either. Curious. Here also, just for historic record, is the original notice of public hearing. And you can see it's the same map that you have.
Yes, ma'am.
So it is part of the district.
Kathy, do you have any comments on the application itself?
My comment is this. Demolition is not preservation. When you demolish a property, it's not preserving it, it's not protecting it, it's not enhancing it. The mission of this board is to preserve, protect, and enhance historic properties. A lot have been lost, and I read in the SPLEA newsletter this month that already this board has demolished 3 contributing properties.
Excuse me. This board hasn't demolished anything.
Okay. Well, 3 have been demolished. Okay? You're right. You give relief from the landmark designation. This board does not demolish. You give relief from landmark designation.
In some cases.
So that's what we are asking for. My husband and I from 52 Lewis Street. We're asking that you, do you need any more, do you want the computer list of when this house was put?
What you presented is good.
Okay.
Our historic consultant, I'm sure, is more than capable of finding additional information as well.
Right, and if he...
Today to make any commentary, so therefore we're a little handicapped in regards to the information.
So I guess the next step is that the board cannot issue a certificate of appropriateness for demolition because demolition is not preservation. But the applicant does have a right to request relief from the landmark designation. The only grounds for relief from that designation is hardship. And according to the code, chapter 65, upon receipt of a denial of the certificate of appropriateness, the applicant, I think, has 10 days to request relief. And and you can have a public hearing on hardship.
That's part of the process, and you're absolutely correct. However, this board hasn't determined that the property is, contributing as of yet. We have not determined that it is a contributing part of the historic district and therefore requires denial of a certificate of appropriateness to demo. We're gathering information now, so
okay.
This is just to finalize our information gathering, and then we'll render a decision.
I also have I have the map that is stamped by George A. Andrews, village clerk, November 18th, 1986, showing Lewis Street. I have the newspaper article that shows the map and also shows when this board incorporated this building into the...
So if you have data and information
This should all be in the building
You
department.
hear me? If you have data and information that you think are germane to this application, my suggestion is that you get a packet put together and you submit it in as part of the evidence of this application, and that way we can review it. It would be easier that way if you think it's important enough that this board review it.
And all this information should be in the building department.
A
So
lot of things should happen.
I guess I just have a hard time understanding why you wouldn't know what was in the district and what
I
wasn't.
understand what you're
Thank
saying.
you.
Charles Bellows, 52 Lewis Street. I'm the neighbor to the applicant to the south. I've lived here all my life, and I'm really amazed, totally shocked. I went to the building inspector's office to review this application, and what do they say? That it's not in a historic district. And I don't understand why the village has evolved into such incompetency as it has over not being able to determine whether or not a property is contributing into the village historic district. And they said, I'm sorry, Mr. Bellows, it's not on the list.
I understand that.
And I foiled for the list.
In the historic district, and then you're also saying not contributing within. It's located in the historic district. What the applicant is saying is not a contributing structure within the historic district. So I just want to make sure we
And I want to tell you, Curtis,
Yes.
that it was based on the list that the building inspector's office had, which is an invalid list. And determinations are being made on applications from an invalid list. So I foiled for the list. I have a copy of that list. And it is the list that Kathy made reference to for the expansion. So this property was not listed as a contributing property. That, sir, is a problem. If this village is handing out inaccurate information to applicants, then we have a serious problem. Go ahead, Ann.
I was saying that the expansion was never approved.
Excuse me.
All right?
Yeah.
Are you okay?
No.
Charlie, you okay?
I got a little problem, but it's okay.
Please, guys, let him have a seat.
Ham, this list.
Please offer him a seat.
This list was an expansion that never was adopted by the village.
Right.
That's the list that the village inspector's office has, that they're using to determine whether or not applications are in the historic district. It is invalid, it is inaccurate, they should not be using that. I have a copy of it. It is wrong.
Okay.
It is creating problems for people. This house, which I've lived next to all my life,
So if
I was part of the procedure that was undertaken by the village going back into the 80s.
if you just give me a second, I think we need like
Where
5
have we come to that we can't determine whether or not a property is contributing?
Charlie, we're going to do a 5-minute recess.
5-minute recess.
I
Okay,
make
is
a
that
motion
okay?
that the board
I'm all
do a
right.
5-minute
All right.
recess.
I second that. All in favor?
Aye. Thank you. 5 minutes, guys.
Motion to reopen, please.
I make a motion to reopen the application,
Reopen the meeting.
to reopen the meeting.
Second. All in favor?
Aye.
Okay. Any additional public comment? We're still on 44 Lewis Street. Please step forward.
Good evening. My name's Greg Andrews. My wife and I live at 60 Lewis Street, which is 2 houses to the south of 44. We're neighbors with Charlie and Kathy Bellows. And we're in opposition to the demolition of the house, and I just wanted to speak to a few things that both of the Bellows said. So we've only lived at 60 Lewis for a little over a year, and part of the reason that we were interested in that neighborhood was for the fact that the historic district and some of the character and charm of the homes on the street. And I understand that there's maybe a little bit of contention as to whether or not the lot is contributing, but from our perspective, we had looked for quite a long time in the neighborhood before we bought, and we were always told of which lots specifically on the street, especially by our broker at Elliman, that was important to us because it's 2 houses away. And while, I do respect the fact that the architect has taken into account the style and flow of the house, the house next to it was significantly expanded, possibly even close to the scope and scale of the proposed 44 Lewis site, but the house was not demolished. And so, we're obviously in favor of progress and raising property values in the neighborhood, but at the same time, I don't see that it's necessary or essential to demolish the home. It may not be architecturally significant and check every box, but it is an older, charming, beautiful house that, we feel should be preserved.
Okay. Just for the record, this board is not interested in making every home expensive. So I just want to make sure you understand that.
Appreciate
Despite
that.
what some people will say, this board is not looking to just make every home an
I didn't mean
expensive
to
home
infer
and
that.
large.
No.
Just want to make sure that we understand that. We are a historic preservation board. We do look for preservation when it's necessary. We do hear commentary on both sides of the argument. Excuse me, and we render a decision based on that. We have not made a decision whether this is contributing, not contributing. We're hearing evidence on it. And as our historic consultant comes in, we would like to hear more from his expertise. I'm hoping that the Bellows will present their information and help us come to a more informed decision than just one side.
So may I ask a question? What is the definitive ruling as to whether a lot is contributing or not? Is it a matter of record? Is it a matter of the ARB deciding?
There are several scopes of recognized or property of significance. We do have a article of well, it would be the scope of historic preservation. Part of that guideline, there are guidelines, standards on what we consider to be a contributing or a property of interest. That is part of our code. One of which obviously is if the property is already within a historic district and is on a national registry. That's it. We're still on the fence on whether this is or is not. Ms. Bellows says she has information. She's presented information. We will review it. We're seeing it for the first time, and then we'll recognize whether the information she's given is valid or not. The other, obviously, is we look at both the architectural design, property of interest, meaning a person is of important parsonage has lived or reside, or a person, a famous architect, designed the home. There are various conditions by which we look at the standard or criteria that we look at standards for property that is contributing.
Thanks.
No worries. Mr. Ford?
Good evening, board members. Sally Spanberg, 68 Moses Lane. I would urge you to be against the demolition of the existing house. It's been in the same family. It's an authentic piece of shingle-style architecture. Collectively, along with number 31, 39, 52, and 60, that's something that goes with its contributing status. In and of itself, many of the houses along Lewis Street may not individually rise to landmark status, but collectively they do so. I would also argue that individually it would meet at least one, if not more, of your landmark criteria for consideration. I just wanted to add that the inventory forms, as far as they go, it has been my experience that they are often missing from the building department. And then I will go to the Historical Museum, which has some copies, but also doesn't have a complete list. If one or the other doesn't have the form I'm looking for, I'll go to the state. The State Office of Historic Preservation has all the forms and all the documents, and they easily distribute them. So if it's missing, turn to them.
Thank you.
Thank you.
Thanks,
Any more public comment?
I just want to make one more comment. This board doesn't decide what's contributing. It's already been decided. It was decided and adopted in '87. And it's based upon the '79 survey, which was adopted by the National Register and the State Register in '88. So you have a contributing building.
Yes, ma'am. Thank you.
Thank you.
Any more public comment?
Okay.
Anything further from the board?
Nope.
All right. Work to be done. We're looking at this. We'll have our consultant here at the next meeting. You'll allow us to adjourn.
Please do.
Motion to approve applicant's request to adjourn.
I make a motion to approve applicant A. Gugliotta, 44 Lewis Street, request to adjourn.
Second.
All in favor?
Aye.
Next application, please.
Mr. Chair, is Lynn Manger, Fairleigh Drive. Demolition of a existing house and rebuild.
Good evening, everybody. I'm here, Bill Manger Jr., representing my mother, Lynn Manger, who's here in the audience, as well as the rest of my family, and Gina Rignan is going to help us as well. So we have come in with an application to tear down a ranch house from 1974 that my parents built 40 years ago this year on the property at 10 Fairleigh Road. I do have some pictures of it. I will submit them. I think there's some in the file, but want to submit.
You're basically taking the 74 house down and putting something that's a little more up to date.
Yes, we're wishing to take down the prefab house from 1974 and replace it with a shingle-style house that is compatible with the house that my family also owns to the immediate south.
Sure. Familiar with that. The question I have is, does this have to comply with FEMA regulations?
So the FEMA regulations are needing to be required with. The survey I have, which I can submit as well, shows that the current elevation is 11 feet.
And it's a VE zone, or?
No, it's an AE,
zone.
14,
Okay.
which means we have to be the first floor at 16 feet.
Right.
You know this.
And then the house height is how?
The house height then is 27 feet from.
27 plus 16 then?
No. 27 plus 5.
Plus 5. So
Right.
you're-
So we're at 32.
32.
So we're well within the 35, even with.
You're 3 feet within the moratorium.
Correct. That's exactly correct.
Right. Okay.
And so we're hoping that the board will look favorably upon that and say that this is not going above that, even though it does have to be raised up.
Confirms that it's in the AE zone?
Yes, it does. And I can submit another one of those as well, Ham.
Yeah.
It should be in the file, but I will submit another one here.
Okay. And this is 2 separate lots, more or less, right?
Correct. There is the house at number 12.
The original house?
Oh, no. No, Sally would not let us do that.
Sorry?
No, it was just a reference to Sally
Your
Spanberg.
house is on her book.
It's on the cover of her book.
So you're in an AE zone, elevation 121.
It's AE 14, and then with the 2 feet required by New York State law, the first floor must be at elevation 16, which is 5 feet higher than the current existing grade. But then from that point to the ridge line is only 27 feet. So 27 plus the 5 to the existing grade, again, is 32, and is well within the 35 height restriction in the village.
Okay. Very good.
I did want to add that, we've tried to incorporate some of the elements from the house immediately to the south in this design that we've submitted. I'll submit these as well. And in fact, the chimney that's being proposed on the house is really to be almost a replica of the chimney that's existing on the house immediately to the south. So I'll submit those pictures as well.
I had some involvement on this application very early on, so I'm going to recuse from this and state purpose of the record.
You're going to pass recusing questions.
Excuse me?
It's okay.
It's a small
house with a lot. And just to let you know, the house that's proposed is only 3,300 square feet, compared to some of the houses that are being built. I think it's half the size of what could be built as of the zoning code. Yes, it's basically in the same footprint as the house that's there. We are going to be saving the Rose of Sharon that's on the front of the existing house. The cryptomerium on the property line are going to remain. The only thing that probably won't remain is some of the foundation planting, which is hydrangeas, but we plan on, putting hydrangeas around the new house when it's completed.
Do you have a landscape plan in mind?
There's no plan.
No plan.
No.
It's a private road, isn't it?
It's a private road, so you really can't see the house from any public area.
Brian, comments?
No, I don't know where we stand with the whole FEMA issue, if we're allowed to be
This
voting
doesn't
on that.
violate the FEMA.
It's within 35
It's only if
feet.
it violates it?
Well, if it encroaches over, I would imagine, my question to council is that, do we have the discretion to make a decision in comparison to one that is within the allowable, even after the moratorium, or as a whole, we should have a unilateral decision on not hearing applications that are...
No, the moratorium says it is the purpose of this local law to temporarily suspend the authority of the Board of Architecture Review and Historic Preservation to grant architecture review under Chapter 116 of the Code and 65 for construction of projects involving proposed one-family dwellings which exceed the maximum height limitation hereafter set forth, and that is 35 feet above grade, average grade at the front of the house.
So hopefully we'll make it by 3 feet.
Right. No, I think the house is beautiful. I think it's a huge improvement from what was there.
It's definitely an improvement, yeah.
It looks like it's was one of the original houses built there, and I think that's what we were trying to accomplish.
That's what we were attempting, yeah.
The details are great. It's terrific.
All right.
I agree
Thank
with
you.
that, and I also like the fact that your gross floor area is way under what you could conceivably have built there.
Thank you.
I think it's a
Yeah.
wonderful plan.
I think it's a step in the direction that most that have this FEMA issue should look towards, looking for a solution to remain under that height requirement restriction. However, we won't go too far in making any recommendations from this board
build
as
up
to
as
what
you
we
go
should do.
anymore.
I know, thank you, Curtis.
However, with that said, we appreciate you taking the extra stand and making sure that it was height responsible.
Yeah.
City public comment. All right. The property is located in the historic district.
Correct.
Therefore, the decision has to be in writing. This board at this time seems to have a favorable vote, so what we will do is we'll close the meeting for written decision by council, which should be prepared at our next meeting.
Which is the 28th, right?
28th.
27th, I think. It's Monday.
Okay.
Today's the 14th.
Today's Tuesday.
Oh, I'm already done. Yeah.
All right, any questions?
No, thank you very much.
There we go.
Okay.
Motion to close the application for written decision.
I make a motion to close the application for Lynn Manger, 10 Fairleigh Road, for written decision by council.
So second.
Second.
All in favor?
Aye.
Final historic application for this
Chair,
evening.
next application is 85 Herrick. Additions.
Good evening to the board. Nicholas Bada, architect. Charles
Ferrazza.
And we're the architects on the project at 85 Herrick Road. And we're proposing 2 small additions, both second floor additions. So from the renderings.
Yeah.
What?
We're proposing small additions to a current residence at 85 Herrick Road, and change in materials, trim details, just to bring it into a more historic, traditional.
Matching existing?
Well, no, we're actually taking the asphalt
enhance
shingles
the
off
asphalt.
and
Right.
replacing them with cedar shingles.
Very good.
We're putting wood windows in instead of the vinyl windows.
And bringing the trim details, these are the existing trim details, which do not have any crown moldings or any historic value really whatsoever, and bringing it into
Or traditional shingle style.
And we have trim detail sheet in the drawings, as well as these renderings. And
I've seen the plan. I have no issue with it. Ham, comments?
Major improvement.
Good improvement.
Fine.
Yeah.
Any public
Love what
comment
you
on the
did.
application? I mean, you can present if you want, but I don't have.
No,
to.
no, that's fine.
Any public comment on the application? Property is located in the historic district. You've heard unfortunately, the process has to be in writing, so we'll have the application, a written decision within the next 2 meetings. It seems that we have, 3 now for a written decision that's outstanding, plus 1 that is carried over. We'll do our best at our next meeting.
Okay.
But just in case, within the next 2 meetings.
Great. Thank you very much. Thank you.
Motion to close the application for written decision.
I make a motion to close the application for 85 Herrick LLC for written decision by council.
Second.
All in favor? Aye.
Aye.
That concludes our historic applications for this evening. First application, non-historic.
Chair, first application is 320 Murray Place for construction of a 2-story house.
You heard the dialogue in the beginning of the meeting with regards to height requirements, possible requirements that from the moratorium and possible change in legislation. This board is taking the position that it's your discretion if you want the application to be heard, but there will be no vote for this evening for the application.
Well, I would like the board to hear the matter and note that this stands on a totally different grounds. It is not in the historic district. So you could take an action this evening. This is the 3rd time this matter has been on, and there's no...
I think the moratorium was individually set forth, just the historic district.
Excuse me? No. I'm saying you don't have the same inability to act this evening because it does not require a written decision. This is the third hearing, and we presented it to you on 2 occasions, and the only reason that it was adjourned last time was because you wanted to give the objections some more time. So we're ready to proceed, so why don't we just do that?
John, just one question, that is, does the board assume that this building does exceed the definitional height of the village law?
The middle
Is it-
section of it, I believe, does not, but the sections on either end.
I believe by 5 feet.
This will have to be raised, needs to be FEMA compliant.
Yes, it does, yeah.
And so it will exceed 35 feet from the average grade level at the front of the building?
Yes, it will.
Okay.
Yeah.
What they're saying is by 5 feet, which is...
No, it exceeds it for a flat roof, so we're not dealing with this. It doesn't exceed the...
Tim, you want to... Yeah.
Sorry, it doesn't exceed the 35, but it exceeds the 27 for a flat
More properly,
roof.
thank you.
It's still...
And how many feet, Tim, are we within the proposed moratorium guideline of 35 feet?
Of 35 feet, we're 2 feet below the 35 feet for a sloped roof. We are 5 feet above the flat roof line
But only for the east and west side, correct, Tim?
for the 2 portions.
The 2 portions, yes. The rest of the house is almost in total outside of it. Yeah.
Right. So we're sort of in the middle of the 8 feet that are between flat and pitched.
You may recall, you want us to present. First of all, Melissa Dedovich, Peconic Environmental. I'm here with our team. This is the 3rd time we've been here. One of the things the board asked us to do was do the mock-up, and the board was kind enough to come today, and we put up the burlap, and I think it was very helpful. Just to remind the board, those 2 sides where they have a height of actually 24 feet, and the middle section has a height of 17 feet. And just per the board's request, I also...
So when you're saying 17 feet, can you...
An actual height.
In actual height?
Correct. From the finished grade of the Phil Broaden.
That's inclusive of the FEMA lift
Correct.
as well?
Correct.
So you're assuming that off the new grade, is that the
Correct.
established grade? What is the difference between the established grade and the new grade? What will that be? Ed?
It's about 7 foot difference.
7 foot difference. So you're at 17 plus 7, is that
Yes.
correct? So you're 23 feet.
Basically.
So you're well within the 35 foot. Okay,
Mhm.
so we need to speak English here.
Sorry.
That's okay.
Okay,
And
this is
really...
not in the historic district. I
No.
saw the mock-up.
Right.
Lisa, I don't know if you had a chance to look at it. It was significant. When I saw the mock-up, you guys did exactly what we had asked. It was very, to me at least, I won't speak to the other board members that were there
It's
this
very
afternoon, but it was extremely helpful. I was concerned, I took a few photographs. I don't know if you put photographs to enter
We just
into
brought,
the
I just,
record.
handed them up, actually.
Okay, all right. I don't, thank you.
Do you want to have a...
So I think the mock-up did its, indicated exactly how much coverage you had on the west elevation, which I think is Mr. Sullivan's concern when he looks east or out of his bedroom and so forth. I'm happy that that tool was employed here. Very clearly, it made my decision absolutely crystal. I think that this house, although I would prefer for it to be shifted back towards the north by 30 or so feet, which neighbors have been discussing for quite some time, I think that the arguments for the impact that it would take on its front entry and flow through is enough for that. I am satisfied that the mock-up proved to me the privacy of the house, the structure, and how it relates to not just that neighbor, but quite frankly to some of the other neighbors as well.
Wonderful.
And I think the landscape plan has been exceptional.
Thank you.
Okay.
I don't think this board had any issues with design.
Thank you.
Landscape plan, placement. I think the issue, obviously, is a little outside of the realm of what this board is normally used to seeing, and that's the pending of quote, change in legislation. I think if it were not a case, we would most certainly have difference of opinion. But as of right now, we're being guided in a direction to take in consideration that, and I'll obviously turn to council as well to make sure that we're in our realm to do so. But we want to make sure that we're not only responsive in this, but we'd have a unilateral decision process for all applications that exceed the exceed the height due to FEMA requirements.
And just
Counsel?
confirmation, I'm sorry, Mr. Chair, confirmation on the flood zone on this property again is
A15.
A15. So you're 15 and 17, so you're at 32 then, correct?
Mhm.
So you're 3 feet under just like the Mangers.
Right.
Right, okay.
Right.
Again,
Wait.
no issues with
We're
that.
outside of the
It has
scope.
Council?
I'm not sure exactly what your question is.
This
Could we hear from Ms. Pastor and Ms. Brady?
Yes. We very much appreciate the time and trouble that you took to give us the answers to our questions, and really a picture is worth 1,000 words. I have absolutely no issue with this, and you've answered all of my questions to satisfaction. And I would want to hear council's opinion after. Brian?
I agree with all that's been said. I have no issues at all. I think it's a beautiful project.
Thank you.
Thank you.
Thank you.
So that stated, of course, subject to public comment. All right. There's no reason whatsoever
Counsel?
you can't
Sure, I
act this
think we're
evening.
there.
Well, I said what I repeat what I said before. You're on the eve of a impending moratorium on this exact issue, and I don't think you should vote on it. I think what the applicant can do is take the colloquy and the commentary of your board and the position of the board this evening and apply for an exemption and let the trustees deal with that.
But
Again-
the trustees are there to decide issues of height. There's no reason why you can't, and indeed you should, of course, subject to public comment, put your thoughts in a decision. That's what you're here to do.
You're talking about this property is underneath that 35-foot.
underneath a 35-foot of
The
a
house exceeds.
pitched house, not
The
a.
house exceeds the height limitation as
As a
described
flat
in the
roof.
village code, which is the purpose of the moratorium.
But it's
We-
not in effect, Bo. It's not in effect. You can't act as if it's in effect.
John, I understand that it is, but I think this board has discretion to act, and I think the board, it's my comment to the board, that it give respect to what the trustees are attempting.
But my point exactly, I will agree with you. This board has the discretion to act, but you're now directing them not to, in effect,
Can I-
based upon a law that doesn't have any effect yet.
Remember, we need to get that exemption before we can go forward with the building permit anyways. So really, what your decision tonight is not going to fast-track anything. It's your decision. It sounds to me, pending result, comments from the neighbors, that this is a decision you're going to have if we come back with our
So keeping
exemptions.
the application open until you receive that approval, again, not.
No, but we spent, this applicant is their third time here, has spent the time and the effort. You know the client, actually, the property owner came out today. Everyone in the last hearing said wonderful things. What I'm hearing, and correct me if I'm wrong, is that you have no aesthetic objections to this project. I don't understand why it can't be acted on tonight. It's not the moratorium is not into effect till tomorrow. I think you're unfairly penalizing our client and the time and the work we've done for this. This is not like it's our first hearing or second hearing, it's our third hearing.
Understood. Let's see if there's any public comments, and then we'll proceed. Any public comment on the application? Please step forward.
Thank you, Mr. Chairman, members of the board. Michael Selensky, 41 Meeting House Lane, Southampton, for the Sullivan family. As this board's aware, the Sullivans did appear without counsel at previous meetings. I'd like to start by urging this board to take the advice of counsel. Just to make sure the record is clear, this property is definitely impacted by the moratorium. Despite that it doesn't meet the 32 requirement because of the flat roof, it definitely is FEMA impacted. The moratorium, without a doubt, impacts this. And this board would be wise to take the advice of counsel and move forward with this application, adjourning it until such time that they either have an exemption or the moratorium has been lifted. In one of the previous hearings, the architect for the application said that this application, when he looked at the property, was an open breath. That was the first thing he said in the application, is that when he looked at the property, this was an open breath. To the Sullivan family who lives next door, when they went out there this morning or yesterday, when the burlap was extended, it showed clearly to them how their property is being strangled by the massing of this property on their property line. I'm going to hand up to the board right now a Google map which shows, how many copies would you like, Mr. Chairman? Is it 2?
Thank you.
Which shows a clear line, a clear character of this neighborhood where all the properties are in line. When you look at the properties starting all the way to the what borders onto Barron Lane, there's a tennis court, there's a structure, there's an open space next to that structure that's part of that property. Then there's my client's house. There's another house that borders that. There's a pool. There's spacing that is developed in this entire property. You also will see that all of the properties line up. When the architect spoke about the architectural design, the vernacular of what this was supposed to be, he wanted it to be a horizon line and for there to be uniformity of the design where it blended into the dune. This isn't going to blend into the dune. It's 30 feet forward of all of the other properties that form this line going all the way across. It's going to be a point affording them a more than 180-degree view at the expense and the view of all the other properties that maintain that line for their views. My client, and I'm going to hand up to the board a number of pictures that were taken showing the views that have come out of my client's property as it looks out towards the burlap section. So I'm just going to hand those up to the board, and you'll see that there's a number of these pictures, and they all show the burlap and how directly impacted my client's property is from the burlap and would be the edge of the. No, I'm
talking about the screening when you're referring to the burlap, correct?
I'm talking the screening. I'm also talking about
screening.
I'm also talking about what sticks above the screening. You're talking about a property that goes. It's going to be fully glassed. It's going to be outside area. There's outside terraced area that's not facing the ocean. That's facing the western portion of the property. That's looking directly into my client's area.
Okay.
It would be very easy for the applicants to move and change the structure to flip it so that the protruding section is on the easterly border of the property, which borders green open space and a tennis court, as opposed to the protruding section being directly located next to my client's bedrooms. In addition, they haven't provided a sample of the glass. They provided a number of indications.
Yeah, you could have taken better pictures of us.
What's that?
So you could have taken better pictures of us.
Well, we didn't want to necessarily.
Well, it's evidence we were there.
Yes, it's We recognize the board was there, and we appreciate the board requiring that the burlap be placed up, because that resulted in.
What is your point?
Our point is that this what is proposed is outside the vernacular and outside the scope of the neighborhood, and the building should be moved back into.
Appreciate the landscaping and screening efforts that were made today.
But those landscaping and screening efforts are just a massing of green foliage on top of their retaining walls that are going to be stacked up directly on the property line, because they're trying to fit a 170-foot wide house on a 300-foot wide property, and they're leaving very little space, as opposed to the current property where it's moved over, and what would maintain the character of the whole strip of houses that go along the entire beachfront area there.
Okay.
That previously you're talking about a moratorium being in place that directs height. This board could request that the house be bigger. We don't know necessarily what the village board will put into place, and that's one of the reasons why.
Say bigger?
Bigger?
What's that?
Bigger, you
I know, so it's
smaller.
Smaller. Well, the village may require less, which would reduce the screening. There's nothing that would reduce the necessity for screening,
what you're saying.
and would allow them to move portions of the property away.
So your major argument is to move the house away from your clients, is that correct?
Is to move the house back so it's in line. So that
In line, but what about the volumetric of it?
we would request that the house be shifted more towards the east, and further away from the western property boundary, because to the east you're bordering on a tennis court and open space, as opposed to bordering on the actual living conditions and bedrooms of our clients. There's no reason why the property can't be shifted further to the east. That's one of the advantages of the modern architecture and the box construction.
You realize that there's a right-of-way to the east on this property that goes north-south,
Correct.
correct?
And my clients are very well aware of that, and that right-of-way was created by the former property owner as a bypass of the right-of-way and the end of Murray Place that used to run down the property line of my client. They took advantage of that, of taking that portion into their property in putting the right-of-way over to the eastern portion of that property.
This applicant is maintaining that, correct?
What's that?
This applicant is maintaining that.
Yes, we're maintaining it.
Maintaining the
public access, correct?
On the eastern portion of the house, not the historical western portion of the property that it used to exist. Historically, the right-of-way.
The question is this, is that pathway, to me, is as important as anything else, but you're saying essentially that you want the house back, the same thing that your client has said, they want the house back, so it's 30 feet, and you want it now moved over.
That completely blocks that.
We're asking that the massing, we're asking that on the location of the property, that the massing of the property be reduced on the western portion of the property, and it be increased on the eastern, where it would be less intrusive into the neighborhood because of the existence of the tennis court and the open space that's there.
Except for the right-of-way that goes.
The right-of-way is a pedestrian right-of-way. You have it available during daylight hours for access to and from the beach. It's not a living condition. If you're going to determine what balances the neighborhood, you're far better moving it towards the right-of-way, which is just a pedestrian access way, as opposed to the living area of my clients.
Where's the file? The file.
But, Mr. Chairman, if I may, the most important portion of the entire argument is that this house is going to be protruding out towards the ocean, which is out of line and out of character with the rest of the neighborhood that exists. It should be moved back in line with all the other properties, so that everyone's afforded the uniform view, and there's not protrusions within.
So is it the view, or is it the privacy issues that your client is concerned with?
It's both, and you accomplish both by moving the property back. Because by moving the property back, you do not have the windows lined up as they currently would exist under this. proposal.
He's talking about this.
Yeah, but the terrace is not facing your lot.
What's that?
The terrace,
The terrace
is not
is
lit-
facing south.
Yes.
Towards the ocean.
South, but it's not. The terrace is on the southwestern corner of the house. That looks directly.
There are no terraces on the southwest. South facing.
South
Maybe on
facing.
the western side of the south. Is that what?
May I
you're-
just?
Yeah, sure. Anyway, so this is outside of the historic district. This is under our 35-foot thing.
You're still saying 35 foot, it still does not comply based
It's-
on the structure that's being proposed, which is a flat roof.
Right.
So,
Yeah.
the argument still doesn't, it still applies.
It still applies.
I'm talking about this second-story terrace that's directly here.
Second-story terrace.
Yes, second-story terrace, which is even more. Of,
I got- Okay.
Anything further?
no, not this time.
Okay. Thank you.
I would just ask that we be able to submit a, based upon seeing the burlap that was exhibited today, we would ask just for 10 days to submit a written memorandum on the issue.
I think that's ridiculous.
Stop.
The burlap was something for the board members to look at, to see how it affected the neighbors. And I think if anything, it demonstrated the fact that the applicants are being very gracious with their screening. I think we've talked about the size of the house, the materials, the massing. We've asked, as a board, we've asked the applicant to drop the house back 30 feet. So, I think this tool that we've requested is not to be used against the applicant, but rather to use.
Well, that's not true. If the
part of the
tool,
application.
if the tool identified a deficiency in the application, then it would be used against them. In this situation, the tool was actually effective. Is that what you're saying?
No. What I'm saying is the issue of moving the house back was addressed already. That wasn't why I wanted to see the screening. I wanted to see the screening specifically, so from John's bedroom as an example, that you wouldn't be able to see this house, that it was a 7-foot step up to the upper roof, to the lower roof, and that I was very pleased with the fact that the landscape architects, the applicants have stepped back the rise of grade, if you will, to facilitate a damn good screening plan. So,
But there still exists an entire glass wall that sits above the screening that looks directly at my client's property.
it's set back fairly far, but look, I'm not saying anything other than the fact that you keep alluding towards a burlap when in fact it's a screening, and I think in a way it's enhancing. Do you see any positive things out of the landscape plan, the way it's designed, whether the house is back 30 feet or forward?
But
would you rather have no screening at all? Is what my point is.
That's not the issue. The issue is the existence of the glass wall that's facing
The
west.
screening argument is the glass wall. Correct?
That's part of it. I'm not going.
And if the glass wall were shifted back 30 feet, would you still have an argument?
No, if the glass wall is shifted back, then it's not looking directly into my client's property. It's looking at my client's driveway. That's the issue.
And would you still ask for that screening as it was placed today, in addition to the 30 feet moving back?
The screening at that point is less of a concern because the issue is the glass wall above the screening far more than it is the screening itself.
Okay. Thank you.
And again, I renew my application to submit a memo.
Any additional public comment?
No?
Just wanted to respond. Mr. Zelinski, I may or may not be familiar with the village code provisions governing your procedure and your powers, but everything that he's talked about is essentially a site plan issue. And I just want to remind the board that the house is actually 122.5 feet from the crest of Dune, where it could be 100 feet from the crest of Dune. And indeed, the Jaffe Design House directly to to the east of the property is quite a bit further out. So these character of the neighborhood arguments regarding the site plan, or site plan issues, and really these setbacks are determined by the crest of the dune and the coastal erosion hazard line. We're, again, 22.5 feet further back from the crest of dune than we could be as a matter of right, which I think is a pretty, reasonable movement on behalf of the applicant. So again, it's very difficult. I know, how do I say this? I know your counsel is suggesting that you don't,
And
you
John,
don't vote on it.
We're agreeing with the council.
Just, can I finish? I'm just,
You
I know
can.
I know it's very difficult, but I'm, particularly for someone who I'm so very fond of, your counsel, but no, I mean, that's important. That's very important. But, people can laugh, but this is a very difficult thing for me to do. All right?
It's okay. John.
Good Lord.
No, come on.
No, what I want to say is it's very difficult for me to ask you to do something contrary to what what Bo has said. But he said you have the discretion, and you do have the discretion. There's nothing prohibiting you from voting on this application. I think you've all been very straightforward, and I appreciate that, about the fact that you seem to have no problems with the aesthetics, the design of the house. So I would simply respectfully request that you put that in the form of a resolution.
Thank you. As you stated, we do have the discretion, and as a board member, I came into the meeting with the understanding that this was the direction I would go. After speaking with the council, it was, in addition to support of council, I agree with his recommendation of this board. I'm a board member, so I turn to my other board members to see how they feel. Esther?
Much as I would really like to approve this, I am not comfortable going against advice of council.
Brian?
I feel the same.
Ham?
I have to agree tonight. Because I'm exhausted. And with that, I'm going home to get in bed. I've had a cold. I think I'm part tonight. That's why all these guys are sitting on that side.
Okay.
And
Any further public comment?
Thank
you. All right. This board's going to adjourn to our next one.
Thank you all.
Motion to adjourn.
I want to go home. You got to go home too. Thank you.
Motion to adjourn?
I make a motion to adjourn the application for 320 Murray Place LLC.
Second.
All in favor?
Aye.
Next application, please.
We're going to have to call next one. Good night, guys.
Feel better.
Feel better, yeah.
Next application is 96 Leo LLC.
I was going to say that.
Oh, sure.
Is the applicant present?
96 Leo LLC.
The applicant present?
Yes.
Okay.
To get internet to help you.
Oh, gosh. Yeah, we got a lot going on.
Let's see where you are.
Wait there. You have your hand right on it. Yes. Building department's gonna hand me in the morning. Yeah.
Evening, my name is Doug Vadge. I'm the building architect for this 96 Leo's Lane. The last time we met with the board, basically the house design I think was approved by the board members. We ran into a difficulty with the landscape plan which had to be resubmitted, and I'm going to pass it along to Dean to discuss that.
We met with the client's representative, being the landscape architect, on the south side, and they're in agreement if we put a hedge of Leland's on that south side.
Your landscape plan has the wrong address.
Sorry.
Your landscape plan has the wrong address.
I'm sorry about that.
Who's the licensed architect? Want to make the correction?
Well,
Landscape architect?
I'm a licensed landscape architect.
Okay.
That's my plan.
Please.
So I think that was the only issue, in the fact that we did not have the plan on file prior to the meeting.
You made the correction? Is that one plan or two plans?
One plan.
You need duplicates? Do you have duplicates?
And how tall are the Leland cypress that?
They're 8 to 10s.
8 to 10s?
They have a 14-foot privet hedge along that border, so they're clear to up about, 4 to 5 feet. So we're covering that hole.
And that was acceptable to the neighbor?
Their lawyer is here, and she okayed the plan.
Okay, so what we had is really landscape plan and the details of the landscape plan. Neighbors had some concerns about a complete landscape plan, what will be there, what will be removed. So, if you give an opportunity for the neighbors to speak with this board, see if there's any issues with any of the recommendations that have been proposed. I'm assuming they've seen this prior to, you've had dialogue with the neighbors?
Right.
It's not, again, a recommendation of this board, but always a suggestion that you speak with the neighbor?
Actively.
All right, so, we'll take the public comment and then we'll come back, so step forward.
Thank you.
Please step forward if you have public comment.
Evelyn Conrad, 18 South Roscoe. Well, of course I'm opposed. There is no 96 Leo's Lane. It does not appear on the plat filed by Leo Roscoe with the Suffolk County Court, with the Suffolk County Clerk. It does not appear on the official document signed by Mulrooney Varadian for the Planning Commission, for the Planning Board, your own Planning Board, when that section for the Roscoe subdivision was approved. There is nothing legal about the notices that were sent up. They're violations of due process because some of them went to people on Ox Pasture Road who, of course, are thrilled not to have more traffic on their road and have it dumped on us in our area. Furthermore, if you send a notice to one owner in the area, that's the violation of equal protection. You're supposed to send it to all. I, of course, have not been notified about any of the crap that you have approved of on Leo's Lane. None of it, I think past 60, legal. I haven't checked it recently because I'm waiting for some other things. However, I should tell you that unlike Mr. Robinson's bogus $10 million suit to get you to approve the replacing of the Paris Concert House.
Do you think we could just focus on this
Excuse me?
application, please?
I beg your pardon. It is relevant, totally
just
relevant.
focus on this one.
Oh, I heard that before when you were giving permission to two spec builders at a time in my area. You say one application at a time when we were talking. Please. And you were giving permission to, what's his name, Kevin Maple, to have two houses.
Do you oppose of the architecture, design, features, color, renderings that are being
I
proposed?
oppose the legality. There is no legality to this entire thing.
Do you
all right?
propose to-
Furthermore,
I understand-
you're all almost qualified now for a RICO case, and you'll get it, because unlike Mr. Robinson's case, mine does go to court. His is purely for show, so if you'll
Okay,
vote
now
for the
it's
substitution.
show
I beg your
voting.
pardon?
First of all, I don't think I will ever get accused of RICO anything.
Oh,
but
you will.
Okay, I guess I'm a gangster now. If you could do me a favor, do you have any issues with the architecture, with the design, with any of the
It's not
features?
relevant. The entire
So that's a no. I'm
addition,
assuming
there
that's a
is no
no?
96 Leo's Lane.
I'm assuming that's a no?
No, it is not. It is telling you that everything you've done relevant to that property is illegal.
Thank you, ma'am.
That's all.
Thank you very much, ma'am. Any other public comment?
Good evening. I'm Alexandra Halsey Storch from Toomey Latham Shan Kelly. I was here last time on behalf of the property owner at 145 Ox Pasture Road, which is adjacent to the 96 Leo Lane property. I thank the applicant for his cooperation. My client doesn't have any objections to the landscape plans or the plans for the home and the pool, as long as it is as it's represented on the plans. That
Not within our jurisdiction.
I'm sorry?
Pool is not within our jurisdiction.
Okay, sure. But as long as what is within your jurisdiction is represented in the plans and is constructed as It's represented. He has no objections.
Thank you.
Thank you for your time.
Any more public comment? Thank you for being cooperative with the neighbors. We appreciate your efforts and your time. I'm sorry?
We have a survey.
Survey was... here.
We don't have a survey on the property that doesn't exist.
Anyway. Seems there's no objection of this board going further. Brian, any issues with the architecture? Anything, any issues with the landscape plan?
No.
Esther?
No issues with the landscape plan, no issues with the architecture.
Thank you. Therefore, a motion to approve.
Make a motion that we approve the application of 96 Leo's Lane.
Second.
All in favor?
Aye.
Aye.
Thanks for your time.
Good
Thank
night.
you. Next application, please.
Next application is Darren Drake, 107 Pulaski Street.
I'm Siu Liu. I'm the architect.
Excuse me, we cannot hear the applicant.
My name is Siu Liu. I'm the architect for 107 Pulaski. The board adjourned last time, so you requested for a site visit. I'm coming back to listen.
If you could step to the microphone, sorry, I'm having
can't hear.
difficulty hearing what you're...
Last time the board adjourned because you need to do site visit.
Okay. Yeah. All right. Board members, did you have the opportunity to review the site?
Yes.
Yes.
Any issues, comments, questions, concerns?
No.
Nope.
Any challenges?
Bless you.
Bless you. Any challenges with the architecture, with the rendering which was being proposed, design?
No. The house is a very nice house.
Any public comment on the application? Thank you very much. Motion to approve.
I make a motion to approve the application for Darren Drake, 107 Pulaski Street.
Second.
All in favor?
Aye.
Aye. Next application, please.
Peter Schoenfeld, 1550 Meadow Lane.
Mark Matthews, 54 Hampton Road, for the applicant.
Thank you.
Good evening. Nice to be here. This is an application to make a small addition to the northwest corner of Peter and Charlotte Schoenfeld's house at 1550 Meadow Lane. It's a flat roof house built in the 80s. It's been added to a few times over the years by me, and we're finally squaring off the northwest corner, and it needed it a long time ago.
We agree.
He finally decided he couldn't stand it without doing it, so we're here before you.
What's the square footage of the addition? That's what I'm getting at the minute.
A total of 230 square feet, 115 on each floor. It's very minor. Yeah.
Brian, any issues?
No, I think it's a huge improvement, and glad to see it's happening.
I completely agree.
Any public comment on the application? Motion to approve.
I make a motion to approve the application for Peter Schoenfeld, 1550 Meadow Lane.
Second.
All in favor?
Aye.
Aye.
Thank you.
Next application, please.
Next application is for Skyfall Lee LLC, 130 Lee Avenue.
little. Yeah.
Good evening, folks. Andy Taylor, architect working with GP Schaefer Architects in New York, here tonight to present a pool pavilion for 130 Lee Avenue. It's an open structure. I'm going to show you the context. I believe you have all the architectural drawings. It's situated here. It is, by definition, a pavilion, an open structure to a park, to a garden. It's got two side rooms, one wet bar pantry, another a changing powder room. And it's open on axis to the pool, which is actually related to the other structures that we presented for you a few months ago. These show the site section, where it's about 13 feet high. It's 30 feet from the south property line. The pool equipment for this structure are housed in a below the building, so they're not in view. The only thing in view is access to it from behind. Going back to the site, we are making sure that there is a lot of landscape to the property line that we're close to for concerns for the neighbor. We're adding another complete row of hedge along that property line and all along Lee Avenue.
What's the height of the hedge that you're adding?
8 feet plus or minus.
What is the
Privet.
depth of the vegetation that you're proposing?
Excuse me?
How wide?
How wide? 30 inches. So, it's a folly in that sense. We're going to construct it out of wood, looking like a tinted structure. It'll be open structure, access to the pool, and clients looking forward to the possibility of enjoying this pavilion off their pool. Again, the material is clapboard. It'll be painted 2 colors to match the other structures on the site, and the roof is standing seam lead coated.
Brian, any issues?
No, I think it's great.
It's really charming.
Yep.
Yep.
Where the
Nice-
property
nice
not
addition.
seen or will not be seen by anyone or any right
Should
of way
be
in
seen.
purview? I'm sorry?
It should be seen.
Any public comment on the application? Motion to approve.
Make a motion to approve Skyfall Lee LLC 130 Lee Avenue.
Second?
All in favor?
Aye.
Thank you very much.
Good night.
Next application, please.
Next application is Twin Cedar Capital LLC, 50 Pelham Street.
I was here before for that sign that you approved. With some.
Yes, you are.
This is the resident we proposed for this application, and it's going to be located on Pelham and Halsey, and it's a small lot and it's a corner lot. And we came up with this design based on the fact that the pyramid would intersect something that it would have been the same as on the other side. So in taking advantage of that, we created this sort of a design which we found and the client found appealing. So the whole house is about 3,200 square feet.
What is the ridge height?
28 feet to the highest point.
The highest point. Okay. Type of brick that you're using?
Pardon me?
Type of brick that's used for the chimney?
Oh, it's a used brick type.
Give a little detail on the is that the mid band there? Is that a? Is it,
Which one? The chimney?
yeah, it looks different in your rendering.
Well, this was probably a rendering that was made without looking much at the. There is a reveal in here on the elevations. That is not shown in the render.
So which is the correct?
The drawings.
The drawings are correct?
This rendering was done prior to having the final design, actually. But the rest is all identical to this.
Other than that, just one little detail?
Right.
Yeah. Okay.
It is nice, actually.
Yeah, this is preferable, actually.
Right.
It's cleaner.
Brian, comments?
No, I think it's a charming little house. Yeah. Scale's good.
Esther?
I have no issues with it. I think it's a nice addition to the neighborhood. Any public comment?
Any public comment on the application? Motion to approve?
Okay. I make a motion to approve the application for Twin Cedar Capital LLC, 50
very
Pelham
much.
Street.
Second.
All in favor? Next application, please.
Next application is Leland Abrams, 107 Wickapog Road.
Good evening, Mr. Chairman. Mayor Ontali, McDonough Conway Architects. I made reduced size drawings so you can handle them easier, and also
Match and replicate exactly what's to
it's
scale?
exactly what you have before you. Yes, sir. And I only have one colored rendering of the project that I printed this afternoon due to limited facilities. That represents the drawings that you have before you. Colors may not completely depict the real colors like the copper colors, and it's because of the printing instruments. The house is a one-family dwelling, 4,592 square feet, of a modest sort of a shingle style, nothing out of ordinary. White windows, cedar shingles, cedar roof, white fascia, and copper gutters and leaders. And by the way, the lot is completely legal, and there's no RICO case against anybody.
30 feet 6.
See the picture?
Oh, sorry.
Yeah. Is there a survey?
I'm sure there is.
Any pictures of the street?
Sure there's not.
Yeah. Okay.
The current house is smaller than the proposed house. I don't know if it matters to the board, Mr. Highsmith, but we're keeping the pool house and the pool, and we're just replacing the dwelling with the proposed.
Okay, so you're not touching the pool house, so...
No, sir. And it's not a spec house. It's for the client and his brother.
Irrelevant.
Irrelevant to the board. I understand.
Irrelevant.
Where's the GSA on this?
Check the building permits and file. Not out of keeping
clear-
the size for Wickapog.
Sorry?
It's not out of keeping
No.
in terms of size in Wickapog. Question is the variations in windows, the different, going from panel to brick to cedar. I mean, from
I have a
the three-dimensional rendering actually helps. It really does help when put in perspective, because when I was looking at it from a one dimension, it was a lot of
Yeah,
going
that's
on.
why we did the rendering, Mr.
I
Highsmith. Yes, sir.
appreciate it. Thank you.
Mm-hmm.
I'd like to see some pictures of the surrounding streets, because most of the houses on that, they're farmhouse
Right.
looking, and therefore they're not very wide on the street. They're long and deep.
Right.
And this is a shallower lot, and it's taking up the whole breadth of the front, and I just want to make sure it's not out of character with the rest of the houses.
Do you have a streetscape?
No, sir, but I know there is a brand-new house that was just constructed, recently completed, to the east of this house, and it's rather close to this property line. I mean, I'm sure they're within the setbacks, but it looks as if it's very close to the property line.
Right, but it has a front porch on it, and it
Right.
has a single gable.
Right,
I mean, you have 3 gables going on in the
Mhm.
front, plus a tower. You know, I'm just concerned that this is going to look out of place on that street.
I think we'd like to see a streetscape with the neighboring houses, if you would be kind enough to do that.
Sure. How far do you want to go, though, Mr. Brady, with the streetscape?
If you could do 2 houses on either side,
Mm-hmm. Okay.
'cause you'll get the 2 newer houses,
Right.
and then this lot, and then the older house.
2 to the east, 2 to the west.
Right.
Okay.
And do we have a landscape plan on this?
And not at this moment, though, unless the board...
I think that would be helpful, or at least to see some photographs as well. It looks like you have quite a few trees, but I don't know if these are real trees or superimposed trees.
No, those are not real trees.
So I'd
would-
like to see a landscape plan, please.
Right.
Second-story deck at the rear of the property is actually pretty prominent.
Mm-hmm.
And so I'm just trying to get my variance in terms of where that's mostly impacted. It's only 31 feet from the neighboring property, correct?
Yeah, it's within the zoning, Ms. Heisman. It's
Not, the zoning's not the
No,
issue, the privacy is.
Right.
So at the second-story deck, what you're doing is that you have a prominent deck where more people are going to gather and I'm sure entertain. You're imposing on the neighbor's
Right.
right of privacy.
I know the board has, and I've been before this board, as you know, the board may have issues with the privacy on the second floor deck, but it's not where people would congregate. It's for the private bedroom.
I know what you're saying.
Right, right.
Still a prominent deck. It's
Right.
pretty big. So whether 1, 2, or 10 people are on the deck, you're still intruding on the person to the adjacent lot on their privacy. And it's at the rear of the lot, so it's their right of privacy as well as yours. To even make any consideration to even consider this, we would need to see a
We will provide a
thorough
buffer.
landscape plan and buffer to indicate a line of sight to show exactly what your observation is going to be to basically remedy whatever privacy issues that you may be imposing on.
So, and I know I've been here many times before, but unlike you, I'm getting very old.
Speak for yourself.
He said unlike.
I'm sorry?
He said unlike.
Oh, okay.
Unlike you, okay?
Thank you, John.
Board would have no issue with the balcony as long as we provide the buffer, the
I didn't say
privacy
that.
buffer.
Let's say that you need to make an argument for us to say it's acceptable.
Okay.
We do need to hear public comment also.
Yes. Anything else on the board? No. Any public comment on the application, please step forward. If you could make way so there's public comment.
Oh, I'm sorry.
Thank you.
Hi, my name is Duran Phillips Flynn. I live at 145 Wickapog Road on Southampton, and it's a few houses to the east of this property. I'm here tonight to oppose the construction of this new home. First, I want to bring to the board's attention that in order to construct this new home, they need zoning board variance, which is on the agenda for next meeting next week. Second, the demolition evaluation report that's in the file is incorrect. I brought a copy with me tonight. Your copy does not include the page 2, which is a photocopy of the existing house. Second, in regards to the village landmark criteria, this evaluation says it meets no criteria, but it actually does. I don't know. I have outlined the information. I know it's kind of a long meeting tonight. I can just include it since you need to review the application. I do have a copy of a letter from the Society for Preservation of Long Island Antiquities, which states that the age of the house is incorrect on the demolition evaluation. The age of the house is actually between 1820 and 1830. It was one of the original farmhouses on Wickapog and was in my family up until 1953. The property was owned by my family since the late 1600s, and it is does have an architectural style of vernacular Greek Revival style, similar to Daniel Halsey's house, which is at 456 Wickapog Road. It was built 10 years after this house. There were 3 historic houses between Old Town Road and Narrow Lane that were totally missed. And this is one of them. Why the historical houses between Narrow Lane and the curve in Wickapog were noted and not these 3 houses, including this one, I have no idea. So I want to submit a letter from the SPLEA regarding the information on this property and its historicalness, and also a copy of the inventory form of the Daniel Halsey house, which is similar to this house.
You do not have one for this house?
No, there is none for this house. No. There should be, but again, there's not.
Well, just so that we know procedurally, the house is not located in the historic district.
I understand that.
Hear me out. So when you go or the applicant goes to file for a demo permit, it doesn't, we are not aware of that unless the building department makes a recommendation based on age to send out our historic consultant to do an evaluation. He'll do a evaluation on the house to see if it is a contributing, outside of the historic district, a contributing structure.
Right.
And warrants designation. For some reason, that didn't happen here. So
Right. So I have some other historical information showing the property.
whatever you have, please provide in.
Okay.
With regards to this house, I know you may comment about similar house down the road, but any information you have with regards to
Okay,
the historical
yeah.
significance of this house would be helpful.
All right. Anyway, I have the old deeds from the late 1600s and the old deeds from the early 1700s showing that this property was there. I also have information from the New York State Historic Preservation on Wickapog and this property in specific. And I also have just the cover letter and the relevant page of the 2009 survey that was done with this house listed.
You make a very valid point, and I'm scratching my head as to why you weren't at least nudged to take a look at this property.
Oh, I was more than nudged. I was requested that I do an evaluation of it, which I did on May the 4th, 2013.
Right, which was for the property owners a few months prior to them putting the property for sale.
Well, in order for one of these forms to be requested, it must be done either by the owner or in writing or by someone whom the owner authorizes to represent their interest. So these forms are not undertaken arbitrarily or by request of someone who is in upstanding with regard to the ownership. And these are routine forms that are requested from time to time from the building department. So, and these have to do with properties which would otherwise, if the owner's wish is to demolish their house, which happens from time to time, that would be of right in areas outside of the boundaries of the historic districts, except in cases in which a particular house is of interest, because it appears to predate 1926. That was the code change some years ago. And all of that procedure was followed. in answer to the initial survey that you're referring to, was done in 1979. And for whatever reason, numerous houses were overlooked throughout the village, or in some cases, they were included in the survey, but the district boundary lines were drawn in such a way that they could not be included. So in either case, there are older homes throughout the village which are not within the boundaries of historic districts. Twice since the creation of the historic district in 1986, the village has undertaken an update of the survey. And once in early 1990s, and the second was a result of my getting a grant from the state of New York to undertake such a survey. And I think the second example of paper that you've passed is as a result of my initiative to identify historic houses of interest, should the village choose to expand or reconsider the boundary lines of the districts. It happens that in this second survey, most recently done, I believe it was 2004 or 5, I'm not certain, but fairly recently, the number of potentially contributing resources within a redefined district boundary would have doubled. From approximately 430 today, it would have been over 800. So all of the historic buildings of interest that exceeded the boundary lines were listed in that revised survey. And that's a record, that's in the record. So, and this happens to be one of those houses, it was identified as such. But understand that it was identified in the context of potentially contributing to the characteristics of an expanding historic district. None of those additional buildings were identified as being worthy of individual designation within the village, which is an entirely different and much higher threshold.
Okay, well, Suffolk
I'm
County and New
explaining
York
that-
State recognizes this house as being
As what?
contributory, to the
To what?
to the area. You can read the letters and
Well, what I'm
the historic
simply-
information that I have on the property, and
I'm
you
simply
know.
trying to explain, and I think you
Oh, I understand. I understand
No,
what
I think
happened.
you misunderstand.
No, I do understand. I do understand that there were historic houses in the village that were contributing and were missed. And
Contributing to what?
contributing to the historic quality of life of Southampton Village.
And what I'm saying is that the village has now twice, since the adoption of the historic districts, has twice undertaken an updated survey of houses of interest that predate a certain period. Realize that when the original survey was done in 1979, houses, let's say, of the 1920s or 30s, were not considered old enough and didn't have enough history at that time.
Right, but this is
And therefore,
1820 to 1830.
simply saying in general, now, if we revisit that survey 30 years later, clearly there are many houses that have gained significance in that length of time.
Is this one of the properties that we should take into consideration for designation?
Yeah, okay.
No, I've already rendered the report, May of 2013. And my conclusion at the time was that this particular house does not meet any of the village criteria for individual designation.
But the district as a whole to be expanded, it would meet within a cluster of homes that are within that area.
It would absolutely be a contributing historic component within a historic district. If boundary lines
right.
such to encompass it.
Okay.
And there are other examples.
So this board, what he's saying is, in order for this board to even take in consideration, recommendation of the historic consultant is that for this board to take in consideration this individual home, it would have to be a part of a overall district, and therefore, if that district line has been expanded, then by nature of the expansion of that district line, the house would be contributing within that district. Since that district line doesn't exist currently, individually, it doesn't rise to the level of we say requirements for designation.
Well, the second most important property in Southampton Village, other than Conscious Point, is the corner of Old Town Road and Wickapog Road, and the farmhouses on Wickapog Road. And I have a copy of a photo I took of the historic sign on the corner of this property I'd like to submit, and I also have a photograph of a granite bench on the corner of this property, stating that this was the site in 1640 where Edward Howe, the founder of Southampton, had his house. So why the land between Old Town Road and Narrow Lane on Wickapog
You made
is
the argument of the district.
not historical.
What I'm saying is you're making a valid
Right, but I would
argument
like
which she agrees
to
with.
have the board take all of this into consideration
And we will.
when it comes to demolition of this house. Secondly, I'm opposed to this new proposal because I do have photographs of the new houses that were built on Wickapog, and they are farmhouses. And this house design is not farmhouse. Second, as far as the second-story deck off the back, there is a house behind this property, and a second-story deck would give views of that whole property and not only adjacent properties. And let me just say, I think that was it. Thank
So
you very
far, we've
much.
agreed with everything you've said,
Mhm.
which is the reason why we want to take further investigation and also have further dialogue
Right. I
with our
appreciate
historic
that.
consultant. But just make sure you're walking away understanding that as a district,
Yeah,
which
I
don't think we're
understand.
opposed to at some point readdressing. I think we need to. We put the work in, and at some point we need to start putting that work into action. We're not opposed to the action. It's just that it takes time, takes effort, takes resources, it takes courage. But we'll try to do the best we can. Thank you. Any further public comment?
Hello, my name's Susan Sherry Clark, and I hadn't realized that.
Back up just a little bit.
Okay.
Okay.
I hadn't realized. Right, this is the one that. I hadn't realized that this was on the agenda, and so I didn't do research on it. But I am familiar somewhat with the house because I think everybody uses Wickapog Road on the way to Watermill during the summertime, and I think the thing. It's what you said about the farmhouses in the area, that there was new construction to the west, and I always felt that they replicated, in a sense, this house. And I actually thought that was not replicated, but they did a reconfiguration of it in the same style, and I thought that was admirable for the new construction. And it would just be, I mean, to me, a crime to lose this house that was replicated next door, sort of to blend in and replace it with something similar to what I saw in that photograph. It's just, it's part of the Vistas part, what I see every day because I go that direction. So I really, and my other research that you did on that, and I'm very opposed to seeing that torn down and replaced.
Thank you. Any further public comment? Okay, anything further from the applicant?
Ms. Clark, what's your address? Where do you,
It's not necessary.
Okay,
I live in the village.
okay, so you have nothing to do with this application. Okay, now, a couple of quick notes for the board members. Yes, the applicant is before the ZBA.
I can't address that over. She has nothing to do with any person that's within the village of Southampton who wishes to speak on any application has the right to do so.
Right,
Well, actually,
absolutely.
any person who wishes to come into our meeting and address anything that has to do with any application has the right to do so. I won't limit it to Southampton Village.
Granted, sir.
Thank you.
Just a couple of quick notes that the board members may not be aware of. Yes, the applicant is before the ZBA to reduce the front yard. But I know you guys have no jurisdiction over it. If you look at the floor plans that I just handed to you, in the rear of the house, we purposely have a very shallow den that is too close to the pool. This house, the way it is designed, would fit the property and would meet the front yard setback. However, the applicant said because of the situation of the existing pool, why don't we push the house towards the street? that requires a variance. If he does not obtain the variance, the house can fit within zoning requirements. And for that reason, we have that den a bit out of style and very shallow, so it is about 12 feet, 11 to 12 feet away from the pool. So his argument with us as the designers were to push the house south, if you will, so he doesn't get too much shadow in his pool. If he does not get the variance, he will be happy. He would just respect the board's decision on his application. So that's one. Number two, before he purchased the property, or when he was in the process of purchasing the property, he obtained the information from Zach back in 2003 that the house had no significant historic value, if you will. I personally walked the house. I don't think that house was built in 1820. I think the house was built probably 60, 70 years ago. And I don't see any historic value to the house. And I have done many houses in the village, as the board knows. So, but I leave that up to you guys and up to the expert. The deck, as the lady mentioned, would be addressed in our landscaping plan, and we would definitely satisfy the board's requirement for privacy issues. And briefly back to the historic value, the house currently is not in a historic district, correct?
Correct.
So it does not meet the historic criteria. So I don't think that should, I mean, if the board or the town or the trustees require or decide to.
At the town, the village.
Yeah, whomever body decides to put that property or acquire a new boundaries for this historic district, that's up to you. But for the moment, for the purpose of this application, we are not in the historic district. I just want to make sure it goes on record. Otherwise, we would have approached it differently. Okay, and that's it. And that's it.
Thank you.
I have no other comments.
There have been comments about, the design of the house, potentially being out of keeping with the remaining portions of the surrounding area, which are more farmhouses. There's issues with regards to the second-story deck, and how it actually may violate privacy of the neighbor. These things have to be, and also streetscape, so that we can get
We will
an idea
address
what-
all those.
Those are the things that this board has requested that you address at the next meeting.
Sure.
Do you have any questions about that?
Next meeting would be 2 weeks, Mr. Chairman?
That's correct, yes.
We'll be ready.
20, have we figured out it's the 28th?
27th.
27th.
Monday, it would be a Monday night?
Yes.
It's Monday, so it's the 27th.
So October 27th.
27th.
Very good. Thank you very much.
Request this board to adjourn so you can follow up with your paperwork, correct?
Thank you.
Motion to approve applicant's request to adjourn.
I make a motion to approve applicant's request to adjourn Leland Abrams, 107 Wickapog Road.
Second.
All in favor?
Aye.
Aye. Next application, please.
Barry and Kate Grayson, 35 Raymond's Lane.
Yeah, that's it. Good evening. I'm Jim McChesney. I'm the architect for this project. There's 3 half-size sets there for you. Basically, what we're planning on doing is keeping the house, knocking off the roof and the second floor and reconfiguring it. The current house now is probably from the 70s. It's outdated. There's a garage in the front of the house. We're going to put a garage addition on the side and push it further back so it's further away from the street. And we're going to just try to make it more of a typical village shingle-style house. So it's an addition on the side with a garage and a new front porch and a second floor and a new roof line.
Definitely extended to his max, didn't you? 34, just shy of 35 feet?
Yeah. The existing house is pretty tall as well. There should be pictures, I believe, in the file.
What's the existing house height?
I don't know the exact height, but it's probably 30
Not
feet.
Not bad.
Can see it.
It's very plain. It has vinyl siding on it, asphalt shingle roof, and we're changing the siding to cedar shingle siding and cedar roof.
I know the interior is not really in our purview, but I'm trying to get an idea of why the roof lines extended so high. What's the ceiling height of the roof, the attic?
It'll just be attic space. We're not finishing it out. What I wanted to do was keep the same angles as the front reversed gables. We're keeping the second floor platform. It's just a new, it's from the second floor up that's new.
Brian, comments?
I have a concern about the height of it too, but I can understand from an architectural standpoint why it's necessary, because he's working off the existing footprint. You know, if you had a new house, you could change the footprint to bring the roof line down, but it's going to look worse if it doesn't line up with the garage. But I'd like to see some of the neighbor houses just to make sure it's not towering over.
There's really, there's a house behind, which is a project of mine, that is close. It's not quite as tall, but it's 2.5 stories.
Esther?
I share the concerns about the height. I'd like to see a streetscape, and I'd like to see a landscape plan. I mean, the design is really lovely. Nice materials. I mean, the lines are clean.
Huge improvement.
Yeah.
It's a huge improvement, but it's just that every portion of the village code is being stretched to its limits. The pyramid law, the height, it's just, my concerns is just the amount of massing that the proposed is being, and how it's going to impact our neighbors.
I mean, I'd love to see if you could bring the height down.
I think it will complicate the roof line. I think that the idea of it was, I mean, the height is kind of necessary to keep the roof line simple. I think that if we start to change the pitch of the roofs, it's going to seem more not as traditional, actually. I think it'll seem like more of a house that's similar to what's there.
But let's take a look at this streetscape,
By streetscape, what
the
do
other
you,
houses, the surrounding houses.
pictures of them, or?
Photo, just a photo. Any public comment on the application? Please step forward.
The two-story mass is only 2/3 of it, so it's not that big. It's just
the height.
My name is Fred Weinfurt. I'm an adjoining property owner of the subject property. This property has about I believe 113-foot frontage on Raymond's Lane. To the east side of the property, there are 2 backyards, one of which is mine. And I would be concerned about the issue has been raised a couple of times this evening about privacy. And since this is going to be a 4,633 square foot dwelling on this property with only 113 road frontage, I'm assuming that this is going to have quite a bit of depth on the property. It's probably going to push the borders of side yard, and I'm concerned about how it would affect the privacy of the backyard, my backyard, and I would assume the adjoining property owner's backyard as well.
You're on the east side?
I'm on the east side, yes.
Well, that's the side of the garage, correct?
No.
This side, here.
Yeah.
That would be the west side with the garage.
Is here, there are the 2 lots here.
Okay.
Again, you raised the issue of how high this is, and I think that would have quite an impact on the backyard, my backyard.
Oh.
And I would
Yes.
ask you to take that into consideration, please.
The
I
only
think the existing garage is on the other side. Maybe he's confused.
The existing garage is on the west side. The
That's
proposed
right.
is being switched over to the east side. So the impact you have is actually
A
realistically a
one-story.
one-story window, which probably is a bedroom, correct?
That's right.
I don't know if you had the opportunity to review the plan?
I have not.
Okay. The original, the garage was on the west side.
Yes.
The east side is where the garage is now being located. So your impact, this is the eastern elevation, your impact will be this window, which is a single window from a bedroom. That would be your privacy issue.
Okay.
And the house does not extend to the second lot next to you at all.
That's right, and we're also pushing the garage doors back further into the property, so they're further away from the street.
So there's really only one window then, looking to the east.
Correct.
To your property.
To your property.
Okay.
Understand?
I do.
Any further, any issue with that, or any other issues that you're concerned with?
No. You raised the issue of screening. That'll be taken into consideration.
Absolutely.
Yeah.
Good.
Okay.
I thank you.
sir. Any further public comment? All right, Jim, a couple of things you have to gather for us at our next meeting. So we'll give you the opportunity to do so. You'll request this board to adjourn so you can prepare that information.
Just ask you what they are.
We're looking for a landscape plan?
By that, what?
Screening.
Screening.
Okay.
We're asking for streetscape. I don't know how much work it would be to reduce just for visual impact. I know what you're saying with regards to the reduction of the roof line, but just for impact, what would it look like? I don't know if you're capable of doing that. I'm sure you can.
Yeah.
Just for impact purposes.
Okay.
Thank you. Motion to approve applicant's request to adjourn.
I make a motion to approve Barry and Kate Grayson, 35 Raymond's Lane, request to adjourn.
Second.
All in favor?
Aye.
Thank you. You ready? Okay.
Good evening. My name is Leslie DeFries. I am the architectural designer for Serena and Brad Bowman, who reside at 6 Carriage Lane. We have proposed plans that are for a first floor addition, a second story addition, a shed, a current shed to a pool house, and a new pool location. The plans are sensitive to the current character and modesty of this neighborhood, which is governed by the cluster zone zoning. The plans follow the current criteria and zoning from my research and help for the building department planners.
Right. That's
Many
what
homes
the
have
cluster
been
zoning is why the pool got set.
remodeled in this area until the house fits the neighborhood. We've gone from a 20-foot current roof to a 23-foot 11 high roof. We are 395 square feet under the maximum lot coverage, and we are 72 square feet under the max floor area.
I've seen this.
Materials?
We are, right now it's a shingles house. We're going to continue the shingles and the white trim. And we've removed much of the hardscape, which is in that front survey with the, you can see the green
Yeah,
background.
I see it.
So,
Anything further, Brian?
No, I think it's a modest addition, done very well.
Yeah,
Esther?
I would agree. It's a very tasteful proposal.
Modest design, no issues, in keeping, looks like it should have been built this way. Any public comment on the application? Motion to approve.
I make a motion to approve Brad and Serena Bowman, 6 Carriage Lane.
Second?
All in favor?
Aye.
Aye.
thank you.
Good luck.
Thanks.
Okay, like I
guess the moment everyone's been waiting for here. Thank you for coming. First of all, we acknowledge our historic consultant who snuck in here in the middle of our meeting, Zach Student-Roth. Just to get you up to date, Zach, his recommendation of, I started with the Historic District by mentioning, obviously, the moratorium, which we are all aware that has been filed, has not been filed yet, but has been received. It will be filed in the morning, but in lieu of that, any application that is impacted by height due to the FEMA restrictions, it would be, this board should take the recommendation to, if allowed to hear testimony, not close any meeting, not make any approval, not make any recommendations on the application until such time as some determination on the law has been made. It is also a recommendation of the board that in hearing new testimony, since there could be a possibility of change, that it may be just a waste of time to do so until we hear more information about what the established law will be, or if it has no impact. It's been brought up this evening that some applicants are filing for a relief from the, you called it I'm sorry, John, your exemption from this law. And this recommendation of the board that if such exemption is filed and approved, then at that time we hear the application. But as of right now, would not be in the best interest of this board, not knowing exactly where we're going forward. It's also been a recommendation of the council of this board that we follow that procedure as well. So it brings us back to 450 Gin Lane, which is on the agenda as a special historic hearing in light of the changes in the pending change in law, and the recommendation of council whether we should hear the application, open the application, or going forward, and also hear the applicant who has a modified rendering of his proposal. You've been caught up, I think.
Thank you.
If I missed anything, please update. With that said, does this board wish to open the application for 450 Gin Lane?
Go.
I don't have the power to make the motion. I just can't think of any reason why the board should hear the testimony. I mean, I know John will have his opinion, but I'm just saying you're going to take testimony and hear it. I can't imagine that this is not going to be impacted by the moratorium. The board can only hear the testimony, and I don't know, John. I just don't understand
Brian,
where it gets
do
anybody.
you have a motion, Brian?
If I may.
I would vote not to open it.
Esther, is there a motion?
Again, under advice of council.
But it is open, and I have the right.
It's not been called to
proceed.
order, and it's not open.
Excuse me, I'm sorry. The hearing has never been closed, so there's no vote to close or not to open. The hearing is open procedurally, and I have the right to proceed. And you can't tell me that I can't proceed based upon a law that's not in effect.
We have based on the council's
It's my counsel
advisement.
to you that you have the discretion not to hear this evening.
Well, let me again tell you what happened to me in West Hampton about 25 years ago.
John, we already told us.
No, well, I would like to tell you again, because this is what happened. The West Hampton Beach Planning Board decided not to process or even hear an application to take the what was then the Five Corners School and convert it to a it was a HIV positive treatment center, and as a result of public pressure, a moratorium was proposed. A public hearing was heard on it, and the moratorium had been sent for consideration and sent for filing. And the Supreme Court, Suffolk County, when the planning board refused to hear the application, said it was improper
for the West Hampton Beach Planning Board not to hear the application because the moratorium was not in effect. So this has been probably the 5th or 6th time before you, and I think you deserve to let this applicant, who has been trying to work towards a solution, I think you deserve just the mere respect for them to hear what these plans are.
We're talking about a meeting. One meeting. We're asking this evening.
It's not one meeting.
Well, it is one meeting.
Because
this
listen,
meeting.
if it comes back, if we go and we get an application for an exemption, and they approve the exemption, which I'll be quite candid with you, given the fact that the houses on either side are substantially higher than even this amended design. I don't know how the board says no to it, but if we come back, I don't want to have to start from square one.
How are
And
you
I want
still
this
gonna
to be
have
able.
to anyway?
No, how can you?
Ham's not here. You're showing us new designs tonight, right?
Well,
there's going to be new information from the moratorium.
No, there may or may not be. There may. Excuse me.
And, right,
please let
we
me
haven't
finish.
heard that.
There may or may not be. So I would think you would grant the applicant just a modicum of respect to show you this new design. And again, you cannot take an action based upon a law that doesn't have any effect.
It's been a recommendation of this board that we wait for either your relief or some further determination on the pending law. So that is the.
I can't. If a law doesn't have any effect, you can't take any action based upon it.
We're not taking action based on a.
Well, you are, because you're refusing to allow the continuation of a hearing that has been opened. You haven't closed
All
the
they're
hearing.
doing is adjourning it.
It's not adjourning it.
Well, you can't adjourn it over my objection if the applicant wants to proceed. You have to have a basis
This
for
board
it.
has the discretion to make such an adjournment.
I would disagree.
Okay. Motion to adjourn the application.
Did you do it? I make a motion.
I made the motion. Motion to adjourn 450 Gin Lane. It's been seconded. All in favor?
Aye.
Aye. Minutes from September 8th. No quorum. Minutes from September 22nd. All right. Board members, you had the opportunity to review.
Yes.
Question, comments, concerns, or issues?
No.
Motion to approve the minutes from September 22nd, 2014.
Make a motion to approve the minutes for September 22, 2014.
Second.
All in favor?
Aye.
And motion to close October 14th, 2014 meeting of the Architectural Board of Review
I make
and
a
Historic
motion
Preservation.
to close the Board of Architectural Review and Historic Preservation for October 14th, 2014.
Been moved and seconded. All in favor? Aye. Good night.